Due to some medical emergency, I have to leave at 12. Not kindly excuse me, my lord. Item number 1 and 4 in the appellate side at 2.
Ask somebody to ask for time, pray for time, I will grant. Call on this.
Item number 1.
What is the leave you are seeking?
My lord, actually the judgment was passed on 17 January 2025. We could not file the requisition, my lord, within time for drawing up and completion of the judgment. It is
Leave is granted.
deeply obliged, my lord.
Leave is granted. At the order recorded, leave is granted as per the prayer of Senate Council
Deeply
for the appeal, for the petition.
Item number 2.
Yes.
Please, your lordship.
Yes,
I
Mr.
put
Gupta.
the alleged contempt number 1.
My lord, your lordship has been pleased to pass an order, my lord, directing the contemners to consider the representation made by my client with regard to getting refund of a money that was deposited by my client as money demand draft with the official liquidator. My lord, it was in connection with a sale that was put up by the official liquidator with regard to a property. My lord, we had not deposited the demand draft, but then we approached the bank, Punjab National Bank, to get the refund. When Punjab National Bank wanted us to get the demand draft countersigned by the official liquidator, they refused to do so. My lord, we had come up before your lordship with a writ. My lord, there your lordship was pleased to pass an order, which is, my lord, at page 21.
Yes.
If your lordship kindly comes, my lord.
They were to decide on your representation.
Yes, within a period of 1 month.
Hmm.
Thereafter, my lord, we had presented the representation. It's long past. The communication of the order is at page 23, but no step has been taken as yet. Lord, my money is being utilized 22 lakhs 22,000 since 2023. I'm just wanting to get the refund. They're
Yes,
not
sir.
doing-
What do you say?
Yes, my lord. The main issue before your lordship is under the challenges with regard to the counter-signing of the demand draft, which was never deposited before the official
You
liquidator.
consider and give that answer to them, give a reply. You have to consider.
Given, my lord.
When?
That they have not annexed, and we have also given a reply to the representation, and that the copy I am carrying with me. And even after that, they have given a notice.
Please file a short affidavit on the next day.
Yes, by annexing
And
all those documents.
annex all those
my lord.
documents, give a copy to them. So that we
My
can.
lord, may I just make one submission?
Yes.
My lord, your lordship knows that all consequential orders can be passed by your lordship with regard to the
Contempt,
enforcement.
it's very difficult.
My lord, the section 12 of the Contempt of Courts Act would,
Does,
my lord, allow.
but not beyond the scope of the contempt.
No, my lord,
The
here-
direction was for them to, the direction was,
My lord.
the direction was for them to consider representation.
Yes,
If they have done that, we cannot go beyond this. So please, Learned Counsel appearing for the alleged contemnor stroke official liquidator submits that in compliance of the order of this court, comma,
No.
the representation of the petitioner has been disposed of and a reply given to the petitioner. Full stop. The alleged contemnor shall file an affidavit in opposition, annexing the relevant documents and making the necessary pleadings in that regard on the next returnable date with an advance copy of the same to the learned advocate for the petitioner. Full stop. The matter shall next be listed on February 28, 2025.
My lord, there are two contemners. The bank is not appearing. My lord, after it was the
Bank
bank's.
has also not
No,
considered.
it was the bank's contention that we should get countersigned by the official liquidator and thereafter present
Regarding
it
the
to them.
representation, official liquidator was to consider.
My lord, my learned friend is saying that they have given an answer.
Record হয়েছে?
You have given an answer.
কি record হয়েছে?
I'm carrying the copies with me.
না, শেষ হলো কি দিয়েছে?
Proceedings in that regard on the next returnable date.
With an advance copy.
Yes, only one instance.
Yes.
It will be too early, my lord, because they're shifting their enter office to the corporate house, which is going to be inaugurated on 25th. Sometimes in the middle of March, my lord.
Middle
Middle of March is difficult. 14th is a holiday. So 7th of March then.
My lord, 7th of March, I'll not be in town, my
Then it
lord.
will be 21st of March.
Of March.
Returnable date March 21, 25.
21.
March 21, 2025.
Returnable dated for it. Affidavit copy of the same. Returnable dated for it.
An advance copy of the. না না সেটা তো আগেই বলেছি
ওটা তো আগে। ঠিক আছে ম্যাম।
আর কিছু বলিনি come back on that date.
Your lordship is not giving any direction with regard to PNB, my lord.
আচ্ছা you have served a copy on the PMB?
Yes, we have.
alleged contempt nurse করে দিন তাহলে আর স্ট্রোক অফিসিয়াল লিকুইডেটরটা কেটে দিন ডাইরেকশনটা হবে alleged contempt nurse এর Please communicate this order to them also.
Your Lordship, in this matter, this is an application for recalling of your Lordship's order. Your Lordship was pleased to give direction for filing affidavit. My learned friend has served me the copy of the affidavit in opposition out of time. My reply is ready, but it will be affirmed today. Was of humbly submitting, let this matter subject to your Lordship's convenience.
Recall means that you want an extension of the time.
My lord, I am seeking my lord, the extension of time to file my affidavit in opposition, my lord.
You are ready with that?
Out of time.
And reply be also, your
This
Lordship.
recall application is for what?
Recalling of your Lordship's order.
Oh, the opposition is in respect to the recall itself. Very well. The time for filing affidavit in opposition is extended till today. Full stop. The affidavit in opposition, which is filed in court today, be kept on record. Full stop. Accordingly, the time for filing reply is extended for a week. Full stop. The matter shall next be listed on February 28, 2025, when the reply shall be filed with an advance copy to the learned advocate for the respondent.
7th March, my lord.
7th March, not 28th. Any difficulty on your part?
No.
Very well. Shall next be listed on March 7, 2025.
Got
Thank you.
Reply.
Next. Yes.
I have argued and filed my written notes on argument.
Yes, yes.
Possibly there.
Fight it. Written notes gulo kothay ache? Both sides.
But I will just indicate one or two things from
Yes.
my note. Let him conclude, my lord. Just more, not beyond.
No, you finish before him because there is no further reply.
Because Lordship is hearing the matter after fortnight, my lord.
Yes.
Lordship takes up the note, my lord, once, my lord.
Yes. Your notes, obviously.
Yes. One or two additional points were taken, which Lordship has probably noted down, my lord. Now, my lord, first point which I argued, my lord, that review is not maintainable, and I cited 3 judgments that I have indicated in paragraph 1. Now, my lord, in paragraph 2, my lord, I have mentioned, my lord, about the orders passed, and I cited one judgment relying on Order 22, Rule 10A, because they have, my lord, relied on 3 judgments, taking the point that my action or act was not bona fide. So to deal with that, to counter with that, my lord, I cited the judgment that, my lord, knowledge came, my lord, when they, my lord, intimated me. And there was a discrepancy to that effect also. The person concerned, he passed away in 2014, but actually this was brought to our notice in 2024, and there was no corrigendum to that effect also. Nothing has been pointed out. So this contact needs to be, my lord, gone into, my lord, if Lordship wants to decide the matter, my lord, on merit. This is, my lord, our second point. So to that, my lord, I, my lord, cited a judgment, my lord, of Supreme Court, Honorable Supreme Court, which says that it is the duty of the pleader to intimate me, my lord, about the fact of the day. Though that relates to suit, my lord, but I always, my lord, on the last day, my lord, on 3 occasions, I submitted the principles analogous thereto will apply, and the analogy has to be drawn as there is no specific provision. Now, the other judgment which I, my lord, cited is 1992 4 SCC 683 on approbate and reprobate, because their conduct is such, my lord, that they have taken money. And when Lordship, my lord, asked me whether the money has been taken on behalf of everybody or the other person, excepting that Aditya Vikram, who has not been impleaded, they also candidly confessed and submitted that the money which has been accepted, that is on behalf of all judgment debtors.
The division bench ordered it 19th
Yes.
of February 21.
No, that is the order of Justice Boshak, my lord.
Achha.
Single bench. It has not gone to division bench. But division bench order, my lord, what it records
Yes.
is about the settlement. It's about the settlement.
Right.
I will come to that. It's about the
Justice
settlement.
Boshak's order is, what is the date of that?
My lord, that order, my lord, is dated, my lord. That Lordship has recorded in my lord's order also.
All right.
Lordship has categorically recorded about that,
I'll look.
certain materials were sold and they have taken money. And it was never pointed out that I'm taking money on behalf of such and such judgment debtors. Rather, on behalf of all judgment debtors, one particular gentleman as constituted attorney.
All right.
So, my lord, on that basis, my lord, I relied on that judgment, my lord. Now, my lord, the next one which I, my lord, referred to, my lord, by relying on a particular provision of law, my lord, that they say it's inseverable, I say severable, because the area has been separately demarcated, bills have been raised on everybody. So if it is severable, the entire execution application can't be dismissed. At best, what they can say, so far as the heirs of Bikram is concerned, that can be considered. And that too, my lord, has been duly taken care of in view of, my lord, Article 136, which they have relied upon. The proviso says, if a suit or a decree, which is execution is sought for, nature of which is injunction, permanent injunction, there is no fixed period of limitation. And here, Lordship, if Lordship sees the award, my Lord, Lordship would find the award is basically of directing the parties and recording the fact that they would, my Lord, fulfill their part of obligation, because it's basically the order award records the fact that the parties have agreed on certain terms and the settlement has been recorded by of letters by both sides advocates, which were taken into consideration, and on that basis, my Lord, finally award was passed. And the settlement says that you would do this and I would do this, and on the contrary, some positive, some negative part, nature of which is an injunction. Like, my Lord, what I say, my Lord, it's like using a car parking space. I would be using 12, not beyond that. So basically, it's a restraint kind of thing that more than that you cannot use. The moment you use it, obviously you have to pay, or otherwise you have to remove it. So it's not a money component, which is execution of which has been sought for. Therefore, clearly, my Lord, this limitation point does not, my Lord, apply. And another thing, my Lord, the real point is Order 1, Rule 10, whether, my Lord, the Section 21 applies. Now, my Lord, Order 1, Rule 10 proviso records the fact about Section 22 of 1877 Act. Corresponding provision is Section 21, which starts with the word suit. But the Order 1, Rule 10, my Lord, says any proceedings. So one judgment I cited on that, my Lord, that the execution is a continuation of a suit. And if that be so, that a principle will apply in case of Section 21 also, principles analogous thereto, and the same analogy has to be drawn. When there is no specific provision, so obviously it cannot be, my Lord said, it's absolutely become redundant, and the person will remain. Then what does it happen? It's simply, my Lord, according to my understanding, is Order 1, Rule 10 will apply, because the execution is a continuation of suit. Subject to limitation means Section 22, corresponding is 21. So obviously that applies to execution also. And, my Lord, they have relied on 2 or 3 judgments, my Lord. And, my Lord, I have tried to distinguish all the judgments, but, my Lord, much reliance was placed on a judgment of 2010, Volume 3, CHN 1995, presided over by Justice Bhaskar Bhattacharya. My Lord, I have shown, my Lord, that paragraph, and I have indicated in my note, paragraph 11, that paragraph 36 of that when supports me. I have placed that it says decree or execution. 2 proceedings, one is original, one is other proceedings. So that particular paragraph, if Lordship sees on the last day I placed it, it clearly supports my contention. And, my Lord, and one judgment I also placed, though there is a conflicting views on that, I placed the judgment on 2011, Volume 3, CTC 632, paragraph 12, which says the Order 1, Rule 10 applies to execution also. They have also placed a judgment.
This
That's like-
APLG and CTC, have you given copies of the judgment?
I have given the copies, my Lord, if Lordship sees, my Lord. I have
Check.
given all the copies of the judgments which I cited.
Very good.
Now, my Lord, the other thing which Lordship said, my Lord, I know, my Lord, that is, my Lord, Lordship said, what about 141? Because it says the other proceedings. Now, my Lord, I have found it, my Lord.
Technically speaking, it's not applicable because
Yes.
original, not an original.
No, my Lord, what it says, my Lord, the exclusion 226, and what it says, specific inclusion.
Order 9?
Order 9, Rule 9.
Yes.
Now, my Lord, even otherwise, I say, my Lord, this 141, since it specifically does not include the execution, my Lord, this may be considered or constitute with Order 1, Rule 10, read with Section 121, to draw a similar analogy.
But that will only be possible if your execution was treated to be an independent original proceeding,
Yes.
which you are saying no.
No, it's a
So
continuation.
Therefore, 141,
So, my Lord,
those
my
would
Lord,
be
let it-
contradictory.
let this be kept aside. My Lord,
Yes.
even otherwise, I said Order 1, Rule 10, read with Section 21 of present act and the prior act of Section 22, my Lord, I am
Yes.
otherwise through.
Right.
So these are my, my Lord, submissions, my Lord.
Thank you. Yes. Yes, sir. Not reply, only on the points. Yes.
But I was trying to open my arguments on the point that 151 possibly will not be applicable.
41.
141 will not be applicable.
Because it is not original proceeding. Or what?
Yes, because and I was carrying judgment, but if your lordship
No, order for
section
execution
140 is not
141, you say execution proceeding is not an original proceeding, therefore 141 does not.
Does
Yeah, you are correct.
and it specifically exclude, and I'm backed by my lord AIN 1962 Supreme Court 1886, which says section 141 is not applicable to.
AIA?
My lord, may I hand up?
I knew, my lord, they will be citing, I am carrying a subsequent judgment. Referring to this, my lord, there's a conflicting view, I must tell your lordship.
141 is not applicable to execution.
1962 903, I think they would be relying on.
188.
And there is a reference of that judgment to a later judgment which I am carrying, that is 1966 Supreme Court 188. It says that order section 141 does not necessarily mean a suit, or, my lord, may I just point it out, original proceedings. It can stretch to applications also.
Does not
So,
say it will not apply to
no,
execution.
it never says. It
Cite
never
to
says.
judgment, cite to judgment, yes.
So I knew you would be probably relying on just paragraph 6 of lordship.
Supreme Court has taken
And there is, my lord, the view is slightly conflicting. I must tell your
And
lordship.
our High Court, starting from 26 Calcutta, has consistently held this. So I am carrying the parent judgment model. This is Calcutta Weekly Notes.
Giving you the reference, my lord. 9, I guess.
This is 30 Calcutta Weekly Notes, page 570.
570.
570. Volume 30, Calcutta Weekly Notes, 570.
This, my lord, I have not included in my note, but I am giving you separately.
Need not? Yes.
AIR 1996 Supreme Court, my lord. I put it to 1888 paragraph 6 if lordship wants.
এই তো এটাই তো তোমার
এটা
হ্যাঁ। দাও দাও দাও। যেটা তুমি পড়েছো ওটা আমরা দাও।
একই পড়ুন, কোনো অসুবিধা নেই। Nothing to hide.
না না না
There's a point of law. Paragraph 6 if lordship sees it.
দে আমাদের জাজমেন্ট গুলো কোথায় এই আমাদের আমি বিদ্যুৎ করে দিলাম No, this does not possibly say, subject to my lord's interpretation, does not relate to any execution.
No,
It's only on
It doesn't say about
original.
execution. It doesn't say about execution. I am on original or not. Just I will indicate that, my lord.
Execution is a proceeding all the same.
Yes, but the judgment
It's a
which I have
non-original
cit-
proceeding.
which I have cited specifically say 141 is not applicable to execution.
Very consider.
Squarely on the point.
Just paragraph 6, my lord, if lordship sees, my lord.
I've seen paragraph 6.
Lordship, see, the earlier judgment was referred to, which he has cited, Maharam versus Harbangs.
Yes.
Now, just few lines above that, my lord, it seems to us, the sentence starts, it seems to us, however, those cases are not relevant for deciding the
But I have
point
not
which is
cited Maharam versus Harban.
no. 19,
I have not cited that. It's a 1962 AIA
No,
960.
62 is later.
It's a three judges. bench.
Yeah, 62 you cited, that is taken note of later.
I think it's Munshiram, what is that?
Fifth line from the bottom of the left.
I think this has been taken care of, this judgment, just one bullet paragraph. Yes, my lord, just my lord, kindly, my lord, come to the next page, my lord, internal page. This part I will not trouble your lordship. It discusses with 141, 146, and there was an addition of party application was filed at the appellate stage. Now, my lord, kindly comes to the next page, my lord.
Yes.
Middle of the sentence, my lord, it starts with similarly recently, my lord.
Next page.
Paragraph
means
6.
page
But I
18.
am probably from SCC online copy.
Yes, we are continuing.
Lordship, got it, my lord?
Similarly, I'm not.
Similarly, recently this court has held. যে আমাকে একবার দেখ
নেই তো,
আচ্ছা আচ্ছা মানে জায়গাটা মিলবে না বিকজ এটা ডাউনলোড করা হয়েছে এসসিসি
মিলছে না।
হ্যাজ টু
না তোমার তো আলাদা, এটা আলাদা।
হ্যাঁ সেটাই দেখাচ্ছি আমি 66,188
না তুমি যেটা দিলে সেটা আলাদা, ওটা অন্য।
হ্যাঁ ওটা এই 66,188 just find it out from the copy which I have handed over to your lordship.
Yes.
That's the AI version.
Similarly, I'm not getting.
Let me just find it out for your lordship. May I, my lord, lordship would find
Which page?
my lord, internal 1891.
1891, yes.
Lordship has got it. Few lines, my lord, from the bottom. Their judgment has been referred to. AIS 1962-903.
Yes.
Just three or four lines from the bottom. Lordship has got it.
Yes.
Yes. That under section 141 of the Arbitration and Conciliation Act and also under 141 of CPC, it was competent.
Yes, their judgment was taken care of. That is
Yes.
what we
Now,
pointed
my
out.
lord, though, yes, just my lord, next
Though,
paragraph.
though,
Though there is no discussion This court has acted upon this view, this expression civil
No,
proceeding.
I read that. That is the one you cited first.
So it says, well, the other proceedings also, not only the original, civil proceeding in 141 is not necessarily confined to an original proceeding like a suit or an application for appointment of guardian, etc. But it applies also to a proceeding which is not an original proceeding. Thus, we say it is not necessary to consider in this case, well,
No, AIA 1962 SC, you
they are
cited.
cited.
This is not the one which I have cited.
No,
No.
you cited a different page.
Yes.
That has been considered. AIS 62. I am citing this one.
62, they have cited AIS 62 Supreme
Nine-
Court.
903.
No, 1886.
86.
Oh, I'm sorry.
The
Totally
different
confused. I'm sorry.
Different judge.
And ours is a 3 judgment.
Oh, then I made a mistake. Absolutely sorry.
Which any particular paragraph?
This lordship can consider.
5-6.
Yes.
Yes.
Their appeal was allowed on this point, but the court, though did not consider the judgment, has not acted upon this view that the expression civil proceeding, it stretches beyond the original.
Mr. Gupta, which paragraph?
Yes. Kindly, my lord, comes to paragraph 26.
হ্যাঁ ঠিক পুরো কপিটা
No,
দেখি
in the SCC online, this would be page 10. The judgment which I had cited. Page 10.
Paragraph
26.
it starts with
Lastly, it was contended. Has the lordship got it? Madam?
yes.
May I place it? Lastly, it was contended that by reason of section 141 of the code, the procedure provided under order 32, rule 7 should be extended to an agreement or a compromise decree entered into by a guardian in respect of an application to set aside a sale under order 21, rule 90 of the code. This argument is that an application under order 21, rule 90 is an independent proceeding, and as the agreement for withdrawing the said proceeding affects the right treated by the sale, it falls within the meaning of the said rule. Then section 141 is quoted. Then kindly Mullet skips 2 paragraphs and kindly sees the last paragraph on that page. This view has ever since been followed. We have already held that the application by the judgmental to set aside a sale is a proceeding in execution, and therefore section 141 will not apply for 2 reasons. Namely, 1, as execution proceedings were continuation of a suit within the meaning of order 32, rule 7 of the code, and the code provided specifically for suits, section 141 could not be invoked. And 2, as we held, that judgment to set aside a sale is a proceeding in execution, and therefore section 141, which applies only to original proceeding, does not apply to such proceeding.
It's a double whammy then.
Yes,
If it's the continuation of the suit, then what happens?
But then it says it will not be applicable to execution.
141 is not necessary then to be applied. Order 1 rule 10 applies directly then.
that is not. Kindly
But
keep
then
aside
kindly sees the
141,
CW
that it will not apply.
kindly sees the
Take
CW
their argument. But what happens to order 1 rule 10 and
CW inter-
If it's a continuation of the suit, then
Yes.
141 is not required.
Then a party
not
cannot go.
required? That is exactly.
Suddenly a party cannot vanish in an execution. So kindly sees that, and whether that is a bona fide, then that has to be seen also. So they can't have the cake and eat it too, in my humble.
Somebody passed away in 2014. You were saying in 2024. Your client, I mean.
Very,
Anyway,
very.
yes, Mr. Gupta, continue.
But kindly sees the CW.
Which
Page 575, if my lord is pleased to turn to.
yes.
এটা দিয়ে নিয়ে নিলি?
My lord, the left-hand side column at page 57. My lord, 6-7 lines from the proceedings in execution are not controlled by order 21 alone, for many other provisions in the code are made applicable to execution proceeding, but it should clearly be understood that such other provisions are not excluded by proceedings in execution by reason of section 141.
But Mr. Gupta, there is a click in this.
Yes, my lord.
Left hand, about middle proceedings in execution are not controlled. by Order 21.
Yes.
Proceedings in execution are not controlled by Order 21 alone. For many other provisions in the code are made applicable to execution proceedings. But it should clearly be understood that such other provisions are not extended to proceedings in execution by reason of Section 140. Other proceedings, it's not governed by Order 21 alone. Execution case is governed by Order 21, which is a proceeding, which is a provision under the Civil Procedure Code. Order 21, not only Order 21, but other provisions have been made applicable. But those are not made applicable by virtue of, by the
141.
root of 141.
Yes.
So those are applicable then by themselves.
Yes. But then, so far as order one
That defeats
applicability is
your
concerned,
cause.
that means, but when order one applicability is concerned, that those judgments I have placed on the last occasion, which also are there in my note, that order one does not apply to execution.
Yes.
So if that is specifically
That
excluded,
judgment says Section 141 does not apply to execution because it's a continuation of the suit. And this judgment says, apart from Order 21, other provisions of
other
this
provisions will
code
apply.
apply.
Yes.
They don't apply by virtue of 141.
They don't apply by virtue of
They
140.
apply by themselves then.
Yes, but
I'll get more time than you to think.
yes, but your lordship
So
will kindly
I'll-
also consider the order one rule 10 judgments which I have cited, that those are not applicable to execution.
Yes. Other judgments have you have also said.
But this possibly is a general authority, and those are specifically saying order one will not apply.
Need not argue extempore on that. We'll consider that.
No, but
It requires much more consideration. Yes.
actually, my lord,
I'm grateful, Muller.
No, he wants to add something.
I would-
Mr.
the
Gupta is not
reply-
finished.
reply-
No, you are finished.
That's it. Acha, let him.
No, he is not finished.
No, no.
I thought he had.
He's trying to coerce you into finishing, Mr. Dev.
No.
My lord, my learned senior friend had proceeded his arguments
Yes.
citing two authorities on review. First is my lord 2006 one Supreme Court cases 509. But if your lordship kindly takes a look at,
Scope of review, what do you want to argue on that?
yes, my lord, I say that I fall within the scope as stated in this judgment itself. My learned senior friend had placed, say, paragraph 12 of this judgment.
This is 2006.
2006 1 SCC
Yes.
509. Has your lordship got it?
Yes. Which paragraph should I look at?
My learned senior friend had placed my paragraph 12. But if your lordship kindly sees, this was relied upon for the proposition
Yes.
that review is not appeal, and two views if possible and one view taken, then it will not be a ground of issues.
Yes.
But I am not joining issues with that. My contention, if your lordship kindly sees, that will lordship kindly sees paragraph 12. But here the finding and the judgment was on the ground that two views would be possible, so my lord, and review is not meant to be. And also, which my learned senior friend had not placed, but it also would, your lordship would consider, paragraph 11, the last sentence at placetum D, that it's not really a rehearing. And if there is no error apparent, may I place that? It was observed that the right of review is not a right of appeal, in the sense that the points which have been decided earlier can be reheard again. It was held that there was neither any error of law apparent on the face of the record, nor any similar legal infirmity justifying the review of the order. But may I read it in a different?
Similar means on the face of the record.
Yes. May I read it in the other form, that in the event there is an error apparent on law,
Yes.
and there is any legal infirmity, then
Of
review
course.
should be maintained.
Yes.
So then I squarely fall within
That would
the
be an error apparent on the face of
Yes.
the order.
So, my lord, here what I say, that my scope of review is I am not re-arguing the matter. My scope of review was only restricted to 3 points. A,
Over 3
applicable to
days, we were
21
just passing time.
No, since he was
Over these 3 days, we were just passing time, not arguing.
not re-arguing the matter on merits. But I was only trying to, my lord,
You're
discuss about the
re-arguing
issue.
applicability of Section 21. But you say it's apparent from the face of the record order.
That 21 is not a
It's a legal error. Correct. Get your point.
and also order 1 rule 10 point, and these 2 points had prevailed upon your lordship
Yes.
in holding that the judgments which I had cited would not be applicable.
Right.
And the third facet for review, third ground for review rather, is that perhaps, my lord, in the order under review, your lordship had not considered this point, that the execution was served on us for the first time in 2024. So immediately on the day it was served, the next available.
It's not about your fault. It's about whether they are at fault.
Yes, exactly. I'm deeply obliged.
No,
So, my
need
lord,
not be obliged for that, because that does not
this is exactly my
necessarily
second argument would have
does not necessarily inure to your benefit. You say that you learned later of the execution case, and so you pointed out later. Absolutely. It's so the pivot of our consideration is whether they were at fault, whether they could have done it earlier. They say they did not know about the death. And the death of this person occurred, Aditya Vikram, prior to the initiation of the execution proceeding. So as on the date of execution proceeding being filed, the heirs were there. They had to be implemented.
I say that if they did not know of the date of the death or the factum of death, they should have arrayed him as a party.
A dead person.
Yes.
All right.
That the bona fide mistake can be not knowledge of the date of death or the name of the heirs.
Yes.
Bona fide mistake cannot be not arraying a judgment debtor in the execution.
Right.
This is where I humbly try to carve the distinction. Now, the other point of the other judgment on the maintainability of the review is the 2022 17 SCC on SCC 255. But again, paragraphs in this judgment 26 and 33 have been pointed out, have been relied upon for the same proposition that a rehearing of the matter will not be permitted. And if the court has to delve into the look into the factual findings and to review the order, then it's not a reviewable in that line. Yes. But I say three simple points which I had argued that those are points of law. Applicability of section 21, order 1, rule 10, and this point. So I need not labor into the facts to point this. Now, your lordship will kindly note that the contention of the petition, I'm sorry, my learned senior friend, is that in the award, everyone has different areas in the property. Separate bills are raised. Not a single scrap of paper shown to your lordship. They chose not to use any affidavit, and there's a submission from the bar. It has also been contended that car parking areas are different, nothing shown. On the contrary,
it is not clear from the award itself.
On the contrary, it says Gupta group. This group, the entire group gets 12 car parkings. So if an entire group gets 12 car parking, the entire group gets certain portions, bills will be raised in the name of Gupta group. This is how the award proceeds. Award, your lordship will kindly read the letter of the lawyer, because that also form part of the award, and the order of the division bench, because these two jointly form part of the consent award. Your lordship will see from the judgment as well as the letter, it refers to a group getting a property. So here there is no demarcation of any nature. There are 4 families in the building. And this person who had passed away is a different family. So, my lord, I say it's inseparable and an award which is not capable of segregation. It's joint, undivided.
No, if the dead person is from a different family, then his shed is not.
It's not demarcated. It's an undivided shed.
He's from the Gupta group.
No, it's from the Gupta group. Gupta group is all the judgment. But it's an undivided share of the Gupta.
All right.
There's no inter se partition.
Right.
Altogether. Apropos, the point which my learned senior friend placed today, that there's a duty of the pleader to inform of the date of death. But I completely bow down to that proposition, but that is not applicable to us. No party whom I was representing had passed away. The 2 who had passed away, I had pointed out previously. He was not impleaded in the wisdom of the plaintiff. The plaintiff chose not to levy execution on him. It's his call. Plaintiff is the execution applicant is the dominus litis. If he chooses not to plead one party, the liability cannot be, in my humble submission, cannot be foisted on the pleader to say some non-party had passed. Now, the other point.
No, you say you did not represent them.
No, he is not party. I cannot represent them. He was not arrayed as a party.
He was a party to the main arbitration proceeding.
But in the execution, he was not added as a party. I did not file vakalatnama.
If execution is a continuation of the suit, as you say,
He was not made a party. Your lordship will never come across any judgment where
he
somebody.
died between the award and the execution case.
Yes.
So on the date of the execution case,
He chose
if it's
not
a
to
continuation,
make one.
it's a continuation of the suit. Isn't it your duty to point out that he has died?
If I am not representing that judgment debtor.
You might not, but somebody else was representing.
No.
In the award itself, he
No,
was not
no,
represented.
I'm not saying in the award. In the
I am
award,
saying about the award.
in the
If it's a continuation, then you represented him in the arbitral proceeding.
I represented in arbitral proceeding, but
Then
in
that
the
duty continued if it's a continuation of the award.
if he chooses not to levy execution against somebody, that's his wisdom. He has chosen not to. Then when I cannot be faulted that I have not pointed.
Yes.
But he has taken a risk of not levying it. But he can file separate execution against separate people. But he has chosen not to execute against him. But I cannot be held at fault when he has served the execution application after 15 years from the date of filing. No, 59 years. 15 years from the date of award, he served the execution application. 9 years from the date of filing, he serves the execution application. And he wants a bona fide approach from me. Now, your lordship will kindly also consider one other point which has been taken is that I, in a GA in connection with the execution, participate and do not object to or rather give my consent to a sale of something, of some tiles or scrap materials which was there. So I cannot approbate and reprobate, and I cannot now turn around and say that this will not. But I have 3 issues, 3 points to deal with. A, there is no estoppel against law. If in the interlocutory proceedings, when the summons have not been served, there's some orders which are passed in my favor. But when the summons is served, I can always file a demurrer. That is my first point. Second is, but this really possibly boils down on the issue of res judicata. That if I have done this, then I cannot be able to do this. But here I say that principles of res judicata will not apply when an issue is not decided. This issue was never decided.
More on estoppel than res judicata.
Yes. So
issue estoppel rather.
Yes. But I was also carrying an authority for res judicata that though between the same parties, it may apply in the same proceeding.
It's a question of res judicata. Nothing was decided.
Nothing was decided. That is what.
There's a question of res judicata here.
So
don't borrow that concept.
Estoppel. And also the fact that I did not represent him. When the order was passed, I got the money. I did not represent him. When I saw upon service of the execution that somebody was not made a party, then I immediately pointed the very next day. And your lordship will not find any time gap between the service of the execution and me pointing out. One other judgment which my learned senior friend had placed. I'm not otherwise distinguishing the judgment on approbate and reprobate cited by my learned senior friend. I'm distinguishing by saying this point which I have just now added. That there's no estoppel against law. So if an award is otherwise inexecutable, then it is. Now, one other thing. Is the knowledge of date of death. Relying on the 2008 Supreme Court cases 321, my learned senior friend had sought to contend that since this was not within the knowledge and there was sufficient cause and the delay.
Which paragraph of their argument?
13 to 17 they had cited. Your lordship is on the note?
Yes.
I'm sorry.
On their note.
Page 3, the continuing paragraph, the unnumbered paragraph.
All right. Yes.
But if your lordship kindly sees this judgment, this is the case of a suit where they did not know of the death and so the abatement was set aside. But in my humble submission, the facts of the case are completely different. Even if I give the benefit of the doubt, though I have produced a paper publication also informing of the date of death and the fact that this person is residing in the society and they are the society, they cannot feign ignorance of the death. Even if we discard those, they should have made him a party. The lack of knowledge can be of the factum of death and the knowledge about the legal heirs. So because they did not make him a party, they cannot come by this indirect route of this judgment that they did not know of this. It's not a question of abatement. Yes. Now, on the point of running and continuous cause of action mode, I had placed in my opening submission that 21 will not apply. I'm not repeating myself. Again, on the point of Order 1, Rule 10 and its applicability to execution, I have also placed judgments which clearly say that. The authorities which my learned senior friend had placed today as well as on the other day, and I'm dealing all together in one, that execution is a continuation of the suit. But if that be so, then there would not have been any limitations specifically provided for execution under the Limitation Act. So, if the Limitation Act specifically provides for a separate period of limitation, then it requires compliance of certain other things apart from what is there in the plaint. And what are those requirements? Your Lordship will kindly have a look at the Code of Civil Procedure once. 3 provisions I shall place from Order 21, which permits the court to dismiss that execution application.
But the judgments you cited on 141, they say it's a continuation. But the same logic also, and the same logic also applies to an appeal which is deemed to be a continuation of the suit.
Yes.
It's a deemed continuation.
Yes, but in
separate provision, separate limitation for appeal is also there.
I understand, but
it's a deemed continuation.
May I try and formulate this?
Obviously, an execution and a suit cannot be the same proceeding, but it's deemed to be a continuation of that proceeding. That's the principle.
Continuation. But may I show 2 things and then try and dispel this? What is troubling your Lordship, or what your Lordship is?
No, your judgments are troubling me. Where it is said in 141 regarding 141 that execution is deemed to be a continuation of the suit, therefore 141 is not applicable.
Yes, but at the same breath, since execution requires certain other compliances also.
Mr. Gupta, you cannot blow hot and cold in the same breath. Execution either is an original separate proceeding where section 141 will be applicable, or it's a continuation of the suit. If it's not a continuation of the suit, it cannot be said that it's not an original proceeding. If it has to be an application, that can only be if it's a continuation of the suit. Either it's independent, it comes up by itself, or it's a continuation of the suit.
I understand.
An application in connection with the suit means an application is a continuity of the suit.
But this is not an application in connection with the suit. This is where I'm trying to carve the distinction.
Then it's an original proceeding. 141 applies. You cannot blow hot and cold in the same time.
But 141 applicability will not
You cannot segregate propositions like this. I mean, the proposition, you are relying on a part proposition, you cannot do that. You have relied on 2 judgments to say 141 is not applicable. Both of which judgments in effect say that 141 is not applicable because it's a continuation of the suit. And now you are saying the converse. You cannot rely on a part of the judgment. Then 141 is applicable. We don't take those judgments.
But may I complete this? Why I am saying so, and then I'll try and dispel this possibly. If your Lordship kindly takes Order 21. First, Rule 11. Rule 11(2) of Order 21, written application. Save as otherwise provided in Sub-Rule 1. I'm sorry.
Rule 11?
Has your lordship got it, my lord?
Got it.
Written application. Save as otherwise provided by sub-rule 1, every application for execution of a decree shall be in writing, signed and verified by the applicant or by some other person, proved to the satisfaction of the court, to be acquainted with the facts of the case, and shall contain in a tabular form the following particulars, namely. Then name of the suit, then name of the parties, that is B. Now kindly takes, my lord, rule 17A. 17(1)(a).
Yes.
May I place 17 first? On receiving an application for execution of a decree provided by Rule 11, Sub-Rule 2, the court shall ascertain whether such of the requirements of Rules 11 to 14 may be applicable to the case have been complied with, and if they have not been complied with, the court shall allow the defect to be remedied, and then and there or within a time to be fixed by it. If the defect, then 1A, if the defect is not so remedied, the court shall reject the application. Now it was a duty cast on the court to see that there was a defect in the execution and no orders could have been passed by the court. There is no duty cast on the pleader. So, if this was not done,
What is the effect?
then the effect, court's mistake, your lordship, is on those possibly that will not prejudice the parties. But
If you say acta security, then the entire execution proceeding orders should go.
orders should go.
That's
Or-
not your prayer. You are seeking a review of a particular application.
I'm
We
saying
cannot expand
somebody
the
should
scope.
be added now.
Never ask for those orders.
I
to
have
be
not
recorded.
asked. It's not my application.
Why
I-
shouldn't it be deemed that the court condoned that delay?
I'm sorry.
Why shouldn't it be deemed that the court did not exercise its jurisdiction under 1A? That is a condonation, deemed condonation of that defect.
There's no adjudication on that.
Deemed.
But non-party, if then that is not a defect, then he cannot add now.
Curable defect.
Then he cannot add now.
Curable defect. Non-party is a curable defect.
After period of limitation, possibly the judge
After you
will-
point out, they did not know of the death. He was dead at the point of time.
He was dead. Yeah, he should have been, dead person should have been added as a party. But it cannot be foisted on me in an adversarial litigation when the plaintiff does not show bona fide or the applicant. They cannot say, I will do whatever I want. My duty is to point.
All right.
But then kindly sees order 21, rule
So
22.
you apply the principle of acta security
No,
nominum.
I say that
If this was not done, it's not acta security,
it was not.
not the act of court.
I'm saying it's a mistake on their part, but not
This
bona
does
fide.
not say so. This says if the defect is not so remedied, the court shall reject the application.
Then
the
it should
court did
reject
not.
the application. Once
Court
it is
has not
pointed out,
rejected the application.
once it is pointed out,
You have to point out, not them. Why should
Once
they
I-
point out my execution application is
I'm not
bad?
saying- I'm not
Please
saying-
reject it.
I'm not saying.
What
I'm
are you
saying
saying?
once it is pointed out now. I'm
It
not
should be
saying
rejected now.
that. Yes. Because after period of limitation, somebody cannot be added.
Please read one again.
Yes, madam.
17(1). Court shall allow the defect to be remedied. Then if your principle is applied, then they have to be allowed to remedy that defect. If they don't do it, then only it will be detected.
Completely bow down. But after period of limitation, this is a defect which is not capable to be remedied. This is my point. Had it been before 12 years, I would not have stood any chance. I would not have raised this point. But after period of limitation, it cannot. And those are the judgments which I had cited, which was negated on the ground that 21 is applicable of the Limitation Act, the proviso to 21. If that 21 goes, then those judgments squarely come in. Now kindly sees order 21, rule 22, my lord, once.
Yes.
Where an application for execution is made more than 2 years after the date of the decree. Then kindly sees after C. The court executing the decree shall issue a notice to the person against whom the execution is applied. So it was a duty on them to serve this execution. Without serving the execution, they are doing all these things. And they serve after.
See, you're going
9
beyond the
years.
review application, sir.
But I am only on the review application on.
This is entirely beyond the review application.
I am only on the review
Could have been
application.
a separate application in the
two
execution.
paragraphs of the order which your lordship had said
It's
that
a new
our
point. You
fault.
are saying the execution case is
It's our
treated for
fault.
non-service of notice.
Your lordship has said that it's our fault and we should have pointed it out earlier. I am saying that it was a duty of the
Again, I
minister.
say it's not a question of your fault. They're not their fault because you did not point out. The pivot is, the focal point is their fault, whether they were at fault or not. Your fault is immaterial here. If it was not pointed out, it was not their fault. That is the premise on which Mr. Dev is proceeding.
But that is not, that can be in a case of a suit. But when some party was already there in the award and he chooses to omit one person, but he may file another execution. But I am not saying that he cannot. In this execution, beyond the period of limitation, because it's an unseverable decree, they cannot execute. This is my point.
Here, no notice was served to anybody.
No notice was served ever. But I have a simple point, my lord, to argue. It's a joint award,
Very simple.
undemarcated. So, my lord, if that be so, and the portions cannot be segregated,
So that you made
it
your,
cannot be executed.
that was there in the.
So I can raise the inexecutability point at any stage.
You cannot raise the inexecutability point in a review application in connection with an order where your point was that whether the execution case is bad, execution application is bad for non-joiner of Aditya Vikram or his heirs. It was not a question of inexecutability either due to Order 21 Rule 22 or inexecutability otherwise. This was the sole consideration.
Absolutely.
That execution application should be held to be time barred against Aditya Vikram or as a whole. Because
It was, your lordship was deciding on an
it's
application for
not
addition of.
inexecutability.
No, your lordship is not
Inexecutability
deciding
is a completely different point. Inexecutability pertains to the award. The award is not executable. And you are taking a point of maintainability of the execution case otherwise in law. The execution, like limitation. It's limitation, you are taking a point.
Possibly there's
After
a-
limitation period, after 12 years, an execution case is not maintainable. That does not render the award inexecutable. The challenge is not on the ground of inexecutability. No, it's not a Section 47 scenario.
Possibly there's a thin line of difference. But what I was trying to harp upon is that your lordship has allowed the Order 1 Rule 10 application. If your lordship is with me that that has been done beyond the period of limitation, that is my challenge, because if those parties are added beyond the period of limitation, then also I cannot challenge the inexecutable because they are now parties. I am trying to.
It's not a question of inexecutability. I repeat that. Inexecutable award is executable otherwise. It's a question of fallacy regarding the filing of the execution case beyond time in respect of a particular.
Adding somebody.
But just possibly they cannot because they have also filed.
Anyway, Mr. Devner.
But
They have
adding,
also filed the execution application independent.
mine is
Not,
within
not
time.
on the
Mine is
That has
within-
nothing to do.
They have sought to add somebody as parties, which I am trying to oppose.
Very well.
But on the ground that if those parties are not there,
So,
then
we're repeating ourselves. Anything else?
yes. But the duty of the pleader to inform of the date of death and to take the, that is not that I have indicated that I was not representing somebody who is not there. I cannot. And the point that I should have taken it at the earliest possible opportunity is a duty which is cast under Order 1 Rule 13, where a non-joiner of a party point has to be taken. Order 1 is inapplicable, so that point goes. The second way I want to attack this argument is that separate executions may be levied against separate persons, unlike a suit. Two award debtors, two judgment debtors, who one's property is in Bombay, one's in Calcutta. Two executions can be filed. They chose not to file against somebody. So now, in this proceeding, beyond the period of limitation, they cannot implicate that person. So this really possibly takes care of this liability of the pleader. I possibly am true, but yes.
Order 1 Rule 13 টা কাছে?
হ্যাঁ,
হ্যাঁ?
হ্যাঁ।
At the first possible
Opportunity,
Is they're saying that they're guilty of that at best, which is not applicable because order one is not. Anything else, Mr. Gupta? That's all. Hearing is concluded. Judgment is reserved on the
Just
what?
30 seconds.
No, 30 seconds.
Very well.
Hearing is reserved.
Very.
Judgment is reserved on the review application.
That letter I had, possibly this was handed over to, should I hand over about that contract? Very, very well.
I'm grateful. I'm grateful.
Grateful, my lord.
Mr. Thakkar, you have concluded?
Yes.
But the last occasion I had indicated there are primarily three limbs of submissions. One, that the award is beyond the reliefs claimed.
Yes.
That is the first limb. Second is that the award is contrary to the fundamental policy of Indian law, in as much as it has granted both the relief of specific performance and the relief of damages in lieu of specific performance. Both cannot be granted. And it has granted both. So it is contrary to the fundamental policy of Indian law. And the third limb of my argument was that the arbitrator has acted in excess of jurisdiction because he has awarded amounts which are not awarded amounts ignoring the specific terms of the contract which contain a bar on damages. These were my three limbs. Now, my lord, on the first limb of my argument, I had shown your lordship, my lord, what the reliefs were. What the reliefs as claimed were even after amendment, and the dispositive part of the award, the amounts which have been granted. Now, my lord, kindly sees the award now, how the arbitrator has, how the tribunal, sorry, my lord, has misconducted itself in granting this relief from the award itself. Your lordship has seen the pleadings as to what the reliefs were, and your lordship has seen what the award was. Now, my lord, kindly see the tribunal's reasoning on this, which shows gross perversity. Kindly come to kindly bear in mind this was a proceeding which was going on ex parte.
Mr. Thakkar, please give me half a minute. এছাড়া আর কোনো note ছিল না?
I just retract one step, my lord,
Yes.
to refresh my memory. Kindly just, for once only, kindly consider the prayers, my lord, which were there. 484, please, my lord. Of convenience compilation, volume 2.
Yes.
Kindly, your lordships have marked 463.4 and 463.5.
Right.
463.4 is damages of 1.7 million for breach of contract. This is the amendment. And 121.1 million for misrepresentation. And these are damages in addition to specific performance, because the only relief was specific performance and damages. That is all that I'm going to repeat. Now, my lord, kindly see the analysis at page 529 onwards.
Yes.
Kindly see the bold heading E at the bottom of the page.
Yes.
Ordering respondents to jointly and severally pay damages to upheld holdings the claimant in the sum of $121.1 million or such other amount as the tribunal may deem to be determined to be appropriate arising from the respondent's misrepresentation. So the tribunal is now considering 463.5 claim on account of misrepresentation. Now, kindly see the fraud claim. The tribunal will 317 at 318.
Yes.
The tribunal considers the fraud claim. Then kindly see the conclusion. Having considers, I'm sorry, paragraph 319. Having considered the parties' submissions, the tribunal's view is that Dr. Azim, the respondent number 2, and the respondent's actions do not amount to fraud. This is the conclusion. There is no fraud. Now, my lord, kindly turns to misrepresentation, which starts at heading 2 at page 532, please, my lord. And kindly see the conclusion at 323. Having considered the claimant's submissions and the evidence on record, the tribunal does not find merit in the claimant's case on this issue for a number of reasons. And then misrepresentation is noticed at 324. I'm not troubling your lordship with the reasons, but the conclusion is that there is no misrepresentation.
Right.
So 463.5 of 121 million goes out of the window. Because that is all there is. Now kindly come to 333, where this conclusion is again stated. The claimant has therefore failed to establish that the respondents misrepresented the revenue the company would receive, because there are several incidents of misrepresentation. So he deals with each of these. He summed them up earlier that there's no misrepresentation. He deals with each of these. And then kindly see 336 is the misrepresentation on the other aspect. The TSHELA order, upon careful consideration, tribunal is of the view claimant has failed to satisfy burden of proof that Dr. Azim misrepresented the recoverability of the TSHELA order. So 336 also goes. Then kindly see 340. It bears mention that it is not the claimant's pleaded case, that this is an instance of misrepresentation ab initio, that the statements were untrue and my lord, kindly permit me to digress. 338.
Yes.
The claimant's case on this issue is again problematic. Your lordship will find this problematic everywhere. Then kindly turn over to.
Started with that argument.
Yes.
It's a problematic.
And I borrowed it from here. The award is problematic, my lord. Then kindly see 350, where the conclusion is. In the circumstances, given the claimant has failed to satisfy its burden of proof that Dr. Azim and Kimberlite are liable for misrepresentation, the issue of damages does not arise. So 121 million on fraud and misrepresentation is gone. Now, my lord, kindly see damages, which is starts at page 547. And this is very important, my lord. Kindly permit me to place this in some length. Lordship will kindly bear in mind now, the exposition here is on claim 463.4, which is limited to $1.7 million damages for breach at page 484. 463.5 has been dealt with earlier, damages for misrepresentation. Now the tribunal is considering damages for breach, and there is no other prayer for damages, my lord, other than 463.4 and 463.5. Other than, my lord, the omnibus prayer, further or other reviews.
Yes.
Now, my lord, kindly see the analysis of damages at 547. Further to the tribunal's conclusions on breach or refusal to give control above. So this is the breach which has been established. The tribunal now considers the following three questions in order to assess claimant's damages claim. When did the breach or refusal to give control occur? What is the loss the claimant has suffered as a result of the breach? And how are the damages to be apportioned? Questions framed perhaps are correct in my respectful submission, my lord. When is the date of the breach? What have you suffered? And how are the damages to be apportioned? Broadly, the heads are correct. Then, my lord, kindly sees date of breach and loss. Regarding the first issue, the claimant's position was initially unclear. On the one hand, the claimant states this. I'm not troubling your lordship. I don't want to go into the merits, but he analyzes, the tribunal itself finds the claimant's position was unclear. And he notes the inconsistency in 358, 359. Then, my lord, kindly come to 360. Subsequently, however, the claimant has clarified its position is that the date of loss is 15 February 2022. This is the date of loss according to the claimant, date of breach, when he lost control of the company. That is what is meant by date of loss. This position is problematic. While it appears the relation between the parties had significantly soured by 15 February 2022, there does not appear to have been an actual breach by respondent numbers 2 to 6 on this date. And then, my lord, all this is dealt with here. Then his conclusion is at 361. In the circumstances, the tribunal finds that the actual date of breach and loss is the date of the EGM, that is the 26th of September 2022. So this is the tribunal's conclusion. I'll show you, when Mr. Bachawat presses his arguments on fraud, I'll show you, lordship, my lord, the significance of pushing back the date. There is a significance why this is done. And that is the fraud aspect which Mr. Bachawat was arguing before your lordship. The tribunal comes to 26 September to aid the claimant in inflating the loss which your lordship analysis which your lordship will see. This date is critical for that, because on 15th February 2022, the assessment of loss was much less. That is why this whole assessment is done. And when I take your lordship through, when Mr. Bachawat will take your lordship through the award, your lordship will see the tribunal has in fact prodded the claimant to adduce evidence, which was none of its business. Your lordships have always held that when a matter is proceeding ex parte, for whatever reason the defendant does not appear, does not file written statement, it is the duty cast on the court to see that the claimant proves his case to the hilt, even beyond more than in an adversarial litigation, because the duty is then cast upon the court to do justice. Here your lordship will see the tribunal goes out of its way to come to the aid and assistance of the claimant. This is one instance. The rest I'll show. The significance of this is very important. But if your lordship is with me that this award of damages itself cannot stand, then your lordship will not be troubled by that. But otherwise, to show the tribunal's conduct, when I say award procured by fraud, which Mr. Bachawat will try to satisfy your lordship, this is one of the very important dates your lordship will bear in mind. Then, my lord, kindly come to. So this finding the tribunal could have done. I'm not saying, my lord, kindly do not take me. I'm not saying that the tribunal could not have come to a different finding, but this finding is of some significance. Now, my lord, kindly come to loss suffered. 363. The next issue is the extent of loss suffered by the claimant. In its amended relief sought, claimant has claimed a sum of $1.7 million or such other amount as the tribunal may determine to be appropriate. This is, my lord, exactly 463.4. The sum of $1.7 million was originally claimed as the loss suffered by Uphealth Inc. due to the deconsolidation of the company. This is submitted to be the lower bound of damages to be awarded. Now pausing here for a minute, my lord. There was no amendment of pleading after this originally claimed. Pleadings were not amended, only the reliefs were split. So there is no originally claimed and subsequently claimed by way of amendment. The pleading is only this. And I'm not going behind the pleading to show your lordship what the pleading was, because I've shown your lordship the only amendment was to the reliefs. There was no amendment to the pleading. So the tribunal itself recognizes that the sum was originally claimed loss suffered due to deconsolidation of the company. Now, this is the test by which the claimant must stand or fail. This is the pleaded case. The tribunal now, kindly see what the tribunal takes upon itself now. Kindly see 364. The tribunal raised several questions regarding how the claimant had quantified its claim. In response, the claimant submitted Professor Len's supplemental expert report dated 25th August 2023. The tribunal held a further hearing on 9th September 2023 and queried Professor Len on his supplemental report and the methodologies he had adopted. In the supplemental report, Professor Len reappraised the loss in projected revenue of the company due to the lack of control to be in the range of $80 million to $170 million, with a midpoint of $125.1 million. In response to the tribunal's query whether the damage calculations would have to be amended, now kindly see. In response to the tribunal's query whether the damage calculation would have to be amended if the date of loss is considered 26 September 2022, the claimant provided an updated calculation in appendix so-and-so of the claimant's response. The re-evaluated damages would be in the range of $70.3 million low scenario to a high of $150.1 million with a midpoint of $110.2 million. Now, the tribunal, my lord, in the course of the hearing, before analyzing the evidence and before coming to a conclusion as to what would be the date of loss, it has, in the course of the hearing, advised the claimant that you need to consider another date of loss. And this is
this finding, para 361 is in the award, the final award.
Correct.
And here it is recorded that prior
the
to
hearing,
that this was done.
Yes, that is what I'm saying. This award has been procured by fraud.
If it was held first, then further exercise was.
I'm grateful.
So I was thinking that line.
Yes.
But it records that it was done.
Yes, no, my lord, kindly also, your lordship will also see one more thing, very important.
Sometimes we find that the loss is from this date.
Yes.
And we ask for calculations from both sides.
Yes.
But
possible.
This was a prior exercise.
This is a prior exercise. The tribunal is putting the claimant on notice that if I am to hold this, then what? And kindly see, this is the supplemental report of Len. So there is a primary report. Then Len comes with a supplemental report. Then he comes with a further calculation. This is the tribunal fishing out evidence. Instead of putting the claimant to prove his case to the hill, this is the tribunal prodding the claimant that you please give me evidence to make an award. And, my lord, now kindly see that what was the test? Deconsolidation of the company is the pleaded case. In 363, 1.7 million deconsolidation of the company, that is the only pleading. Now we have a figure of 150 million. On what ground? Loss of due to the lack of control. This is now a new case, and the basis for assessment of damages is now shifted. There's a paradigm shift. A, on the basis on which damages is to be claimed, and B, on the quantum without any change in pleading. Now, can you see 365, how it is contrary to 363? For avoidance of doubt, the tribunal notes that the damages sought in paragraph 463.4 of the SOC as amended relates to the losses flowing from the lack of actual control. Kindly pause here for a minute, Willard. This is not the basis because the tribunal has itself noted deconsolidation of the company. What is deconsolidation? I'll show you, Lordship, from the brief. But I'm showing you, Lordship, first from the award. Kindly see that different terminology used. What was 1.7 million for A cannot become 150 million for A. By no stretch of imagination. Now here is where the mischief comes in. 463.4 is not for actual control. It is not. It does not include any damages arising from misrepresentation. No difficulty. This is clearly borne out from 463.4, 463.5. Now this is the clarification. Now, Malad, kindly see this is a transcript of the hearing where the tribunal has noted, set out. But in terms of damages, your Lordship has that, Malad?
Yes.
But in terms of the damages, which I think was your specific question, could we go down to the damages section? So this is the transcript, Malad, they record everything. So here in 463.4, we've named the respondents that we say are liable for the breach of contract that led to the loss of control, or rather the failure to hand over control at any point. This argument is now developed in course of arguments. We stated that the current event study amount that is linked to, that is the 1.7. That is 1.7 is the amount claimed, except that, of course, that's lower bound. It doesn't reflect the fact that the market had already fully absorbed the knowledge of that lack of control, which is what led for the supplemental report at the tribunal's prodding, which is now the supplemental report from Professor Len. And so where we say, or such other amount as the tribunal may determine to be appropriate arising from these breaches of contract that is sought jointly and severally as amongst those respondents listed. Now he falls back in the course of argument. The tribunal may determine any amount. I claim 1.7, but you please give me 120 as per Len's report. That is his argument. And why? Now, your Lordship will also note the date. This is very important. It doesn't reflect the fact that the market had already fully absorbed the knowledge of that lack of control. This is where the date change happens. When does the market absorb the date? That is why February to September. Mr. Bachawat will elaborate on this, Malad, but there'll be some repetition. Kindly permit us, Malad. Then, Malad, kindly come to 366. The tribunal finds the modified basis on which Professor Len has calculated the losses suffered to be generally appropriate. Professor Len has prepared a supplemental report on the basis that if the claimant had been in actual control of the company, it could have implemented the required financial, contracting, legal and operational controls and processes and made value-enhancing improvements, company being the target company Glocal. The tribunal is satisfied that had the respondents observed their obligations, the claimant could have implemented the report's recommendations in the McKinsey reports. Professor Len has assessed damages on a discounted cash flow analysis of the value of the business improvements initiatives recommended by McKinsey, which were not implemented because of the respondents' alleged breach of contract. Now, the tribunal, when it makes all these observations, it's notice 73. It does only lip service to 73. These are all, if I had come into control, I would have done what McKinsey told me to do, then the profit of the company would have gone up so much. This is not what 73 says with the greatest of respect. I did not come into control. Therefore, I did not do what McKinsey told me to do. If I had done what McKinsey told me, that is the recommendations in McKinsey, the projected profit would have been so much. This is the basis of the claim.
This is based on ifs. Conjectures.
Everything. And remoteness of damages. Where does he say, my lord? The first thing which has to be shown is the parties knew that at the time of entering into the agreement, this would be the losses which would arise naturally in the usual course of things from my breach. These can by no stretch of imagination can be said to be in my contemplation. These are all projections. McKinsey report is a projection that you infuse 5 million, you will make profit of 10 million. Now, if you make profit of 10 million, your share value will go up to this much. And therefore, this is the discounted cash flow method. I've suffered this loss.
So this is a projected and not actual basis of
No,
loss.
nothing. Your lordship sees, it says, tribunal is
Would have implemented recommendations.
Yes, would have implemented. He first has to establish, he first has to establish that when he entered into the contract with me, he had put me on notice that I will take over the company and I will do the McKinsey work and whatever McKinsey recommendations are, and my profit will go so much. That is the first limb of 73. Knowledge of the parties when they entered into the contract, number one. Second, he has to show that I had the wherewithal to implement the McKinsey report. I had the necessary finances to do what McKinsey told me to do. There's no finding on any of this. That but for the respondent's breach, claimant had the wherewithal to accomplish the McKinsey. Now, whether it would have done it or not is a separate question. But first things first, whether it had the money to do what McKinsey required him to do. That is not there. And then the projections of McKinsey. Now, if you put in so much money, you will get so much. This is entirely projection. Even if 1 and 2 succeed, must fail on 3, on unforeseeability. So this is the whole basis now. And this is all at the instance of the tribunal. The claimant did not come up with this fancy exercise. All at the instance of the tribunal. Then, my lord kindly sees 367. The tribunal, in principle, this is the analysis now on his money. In principle, the tribunal considers this approach to analyzing damages to be appropriate. Mr. Beck testified that the claimant was then in a position to inject capital, make the necessary value additions to the company, and implement the recommendations in the McKinsey report. And then kindly see, my lord, on what basis. I understand. Well, just pausing here for a minute. Now the courts have held, Supreme Court now in the curative has held, that if the analysis of evidence is so unreasonable and shocking the conscience of the court, then the court in a 34 can also reappreciate evidence. Earlier, the test was if evidence has been appreciated, court cannot reappreciate the findings. But now that has been widened because we are aware of how arbitrations are going on. It's not a very happy scenario overall. So that is why your lordships are stepping.
Counterproductive.
Yes. Now it's becoming counterproductive because it's again the litigant is not getting any benefit unless we have an institutionalized arbitration.
It is also being revisited whether we can modify, the courts can modify.
Yes, the larger bench is now visiting.
Which is a very relevant thing. I mean, you cannot modify set in stone.
Set in stone
is an absurd proposition.
You can reduce. Your lordships have
Yes, right. You can modify without saying modify.
Yes.
And if they're segregable, you can set aside.
Yes.
Sometimes modification would save so much time and costs.
A second round of
which is the basis of arbitration. I mean. Whatever.
So, Malad,
let us wait the outcome of that consideration before the Supreme.
So we are now at the nascent stage of arbitration, and Malad, unfortunately, Malad, our courts have an impression that the rest of the world is far more progressive than us in this matter.
Yeah, I do have that impression.
That is not.
I do have that impression.
No, Malad, but the greatest of.
You're absolutely right. You have hit the nail on the head.
Yeah, this is the impression.
Not the entire rest of the world, but some parts of the world.
Countries.
Definitely.
Yes.
At least, because I am an outsider to this jurisdiction, initially I was at least.
Yes.
So I've done some reading.
Malad, your lordship is not
my impression is that.
Malad. This is a common refrain.
My impression is that.
That is a common refrain. This is a common refrain that we are lagging behind and the rest of
not in all respects.
Yes. In this arbitration.
In arbitration.
Commercial arbitrations.
At least the speed.
Yes. The speed, yes. Maybe the speed, but not on
I'm only on the speed.
On the justice delivery by the arbitration. What is more important is, Malad, I have a little bit of experience in these matters, Malad.
A little bit.
Very little, Malad. In an arbitration where there is an Indian against a European and there's a European tribunal, more chances or more often than not, the Indian will lose for the simple reason that the membership to that panel, to that tribunal is in the hands of the Europeans. For example, a phosphor arbitration, the Federation of Oilseeds and Fats Association, it is controlled entirely by Europeans and the oil producing countries, that is Malaysia, Indonesia, etc. So there you don't have an Indian representation, and it's a
And even legal opinions, Mr. Tucker, I have had occasion in a different context to come across legal opinions of people from
Yes.
different countries, but legal opinions given in India are of a very high standard.
Yes,
Very, very high standard.
we take
As compared to-
responsibility.
Yes, as compared to even some part, I mean, at least at some levels in UK and US.
Yes.
At least that's my limited
Yes.
impression.
So, my lord, this we have to get.
Legal opinion is very good here.
My lord, our judiciary, with the greatest of respect, has to be
We are
disabused.
dependent on the legal opinions ultimately, so that's a reflection on the legal opinions.
Remember, your lordships have to, with the greatest of respect, disabused of this conception that whatever comes from the West is
No,
good.
no. That I never.
That your lordship will find as a constant refrain.
I'm only regarding the speed. The
Speed may be there, but not at the cost of justice
at
delivery.
the cost of justice. Yes, we have to balance.
Yes, somewhere you have to balance.
Our balance tilts more in favor of justice.
Yes, we are more justice oriented. That may or may not be.
May or may not be there.
Yes,
Time
in
will tell.
commercial matters.
Time will tell.
Time will tell. But this kind of an approach is not melodic, and this is ICC arbitration with an Indian,
Yes.
with an Indian tribunal, with an Indian member on board.
Right.
So, Malad, then kindly sees.
Yes.
In principle, tribunal considers this approach to analyzing damages to be appropriate, so and so. Then kindly see, he states, this is the evidence now which is considered. Beck's supplemental, your lordship will see 473, and the footnote there is Beck's supplemental witness statement at the bottom of the page.
Yes.
I understand the tribunal has asked whether Uphealth Holdings would have provided the working capital necessary to implement the business improvements initiated by McKinsey. Initiatives McKinsey had recommended for local healthcare. The answer is that Uphealth Holdings was fully prepared to provide the working capital needed to transition local healthcare to a profitable growth model. As I explained in my first statement, that is the witness statement, Uphealth Holdings provided local healthcare with 5.5 million worth of working capital, more than what was necessary under the original SPA as amended. In addition, local healthcare hospitals were no longer encumbered with debt because Uphealth Holdings had paid off that debt. This was with the 5.5 million. As a result, those hospital operations were expected to be the source of working capital. Now, so source of working capital is my hospital's operations. Then, in addition, Uphealth Holdings was in the process of securing additional debt financing for local healthcare, which would have more than covered any additional capital requirements. I personally met with the manager of ICICI Bank during several trips to India in the spring of 2002 to discuss borrowing up to $20 million in working capital using local healthcare's now unencumbered hospitals as collateral. I described these efforts in public earning calls in the first and second quarters of so-and-so. Dr. Azim is also familiar with these efforts because, so my lord, it's not his own money. My hospitals, he's going to mortgage and, my lord, raise funds from ICICI. He doesn't even have a sanction letter. This is, kindly see the quality of his evidence. I met the manager of ICICI Bank during several trips in India in the spring of 2022 to discuss borrowing up to 20 million in working capital. This is now bank's sanctioned funds. And this is, my lord, the first limb that this is his financial ability to implement McKinsey's report. This is the only evidence on record. On the basis of this evidence, have been saddled with punitive damage. This is the only evidence. This is the award. Not there in the first statement, comes only in the second statement. And he says, I understand the tribunal has asked. This tribunal is taking upon itself the entire exercise to establish the claimant's case. The claimant did not come forward with any of this. The witness statement starts with this. I understand the tribunal is now asking me, and I come forward with a supplemental witness statement. This is clear fraud, my lord. Mr. Bachawat will show your lordship, my lord, how the arbitration has proceeded. And this is the only evidence on financial ability to earn damages. I met ICICI manager over a cup of coffee in my several trips all over India. I added the coffee. I'm sure ICICI was hospitable with the coffee. But this is not sanction of a loan. And that to $20 million. And he doesn't say, I have the money myself. I would-
Nowadays, hospitals have more of an aroma of coffee than.
Yes. They're all these corporate hospitals now, man. It's all corporate, institutionalized. Singapore money is coming and Manipal is buying out everybody. So now we have, I don't know why the Competition Commission doesn't wake up to this, that every hospital is now owned by one chain in
We
Calcutta.
love to sleep. Mr. Thakur will resume in 5 minutes.
Please.
I'll just Yes.
Yes, please, my lord. So, my lord, your lordship has now seen 367. The capability of the claimant to carry out McKinsey's recommendations is on the basis of $20 million loan, which would come from ICICI. And all that it would come is from several trips to India. He had met ICICI officials. Then, my lord, paragraph 368, he considers Mr. Beck has also testified that UpHealth Inc. had implemented pertinent recommendations from McKinsey successfully. Now, my lord, kindly bear in mind, UpHealth Inc., your lordship will see McKinsey's recommendations are adopted by UpHealth Inc. Improve to improve financial performance by UpHealth Inc., etc. These are all what UpHealth Inc. has done in its own business. Your lordship will see 22 and 23, which is set out. None of this talks of implementing McKinsey recommendations in the business of the target company, Glocal. These are all implementations in its other businesses. Now, can you see 369? What is the conclusion? Mr. Beck came across as a forthright witness, and his testimony was largely corroborated by documentation and the incontrovertible occurrence of evidence. Documentation on a $20 million loan, which is the catch, is meetings. That said, it bears mention that the claimant was in the process of securing additional debt financing from ICICI Bank to fund the company's operations. It is unclear what conditions may have been attached to the debt financing and how it would have affected the company. This, my lord, 369 begs the question with the greatest of respect, my lord. It is what conditions may have been attached to the debt financing, but the first condition is whether the debt financing would have come through at all or not. Conditions come subsequent. But whether ICICI had even given an in-principle sanction, when he talks of corroborated by documentation, and this is the only evidence which he refers to, the personal meetings. So there's no documentation. There's not even a record of, my lord, exchange of correspondence with ICICI where there's a proposal, there's a negotiation that yes, now we are in principle, we are agreed to give you a loan, provided you give us this. That is how, my lord, big ticket loans of $20 are given. There's nothing. There's not even a shred of paper. And he talks of documentation. I could have taken your lordship through the pleadings and the witness statements, but not required because this is the award. This is the analysis of appreciation of evidence at the end of the day. Then, my lord, 370, respondents' lack of support in implementing McKinsey. I'm not troubling your lordship with that. Now, my lord, kindly see what McKinsey had proposed. 554, if your lordship turns over.
Yes.
For completeness, your lordship has that. This is what McKinsey had proposed. For completeness, the initiatives proposed by McKinsey are set out. Increase utilization at existing hospitals. Improve Improve ARPOB in line with regional benchmarks, expand pharmacy, sell more digital hospitals, build and run digital hospitals, increase utilization of existing digital dispensaries, build new digital dispensaries, sell standalone. These are all, my lord, projections. All things which have to be done, then the revenue will go up. Now, if all these were done in a best case scenario, then this is the profit analysis of Dr. Len. My lord, ARPOB stands average revenue per occupied bed. Because in this hospital industry, my lord, average revenue per occupied bed.
But Mr. Thakkar, according to you, what could have been a reasonable basis? Some amount of projection is required, although based, grounded on factual premise. So what could have been an alternative mode of, I mean, just for a...
Well, damages in addition to specific performance. If I was given the company, so my lord, if I were
What
given...
could have been a basis? Suppose let us...
let us keep this aside. Now, my lord, if I were to file a suit for damages for not getting control of a company, one is, the first and foremost test is, my lord, as a shareholder, I am only entitled to the dividend which a company makes. That is settles in Bachaev Gusdar. Shareholder is only entitled to
Yes.
dividend, nothing else. Now comes the second test, that if I had a controlling block of shares, then I was Ratan Tata, I would have taken my company somewhere. But can that be a test for measure of damages? I ask myself.
What would be?
That controlling block of shares would give you the controlling block of dividend. Not that with my controlling block of shares, I would have leveraged my business connections, my expertise, my experience, and would have taken the company from a $1 million company to a $100 million company. That, with the greatest of respect, my Lord, will fail on the test of remote foreseeability. It would fail on the test of foreseeability. And 73 is one of the ingredients is foreseeability. These are, my Lord, all projections, market fluctuations. These are all probabilities. They all surmise and conjecture at the end of the day. This is what he says: improve average revenue per occupied bed. McKinsey says do all this. So a share purchase agreement, specific performance would be, if these are shares of a company which are not easily available in the market, privately held company, specific performance. Damages in addition to specific damages in lieu of specific performance. If I would have the shares of this company, I would have got so much in dividend. Or these or if in a best case scenario, I would have become the notional owner of so many assets. Even that was not permissible in law. So where does the question of profitability on basis of projections come? And this is entirely profitability on projections. I would have done this. I had the money to do this. I would have done this. If I had done this, I would have earned so much. It's telling, my Lord, kindly now see 372. The tribunal itself says that all this was not claimed. What I told you, Lordship, about the first instance, 372. In contrast, now he says in contrast. Unfortunately, my Lord, this is his wisdom now. In contrast, the claimant's assessment of damages at $1.7 million being the reduction in share value of UpHealth Inc. due to deconsolidation is neither appropriate nor useful. This was the pleaded case. I kept telling your Lordship, deconsolidation is not the same as profit margin. The tribunal comes to a finding that the pleaded case is inappropriate. If the pleaded case is inappropriate, then I'm sorry. There's no damages. The claimant has to prove its pleaded case. It cannot prove the case where the tribunal cannot make out a case for the claimant. This is it. The pleaded case, my Lord, was, I'll tell you, Lordship, what the pleaded case was in a one-liner. And I'll show you, Lordship, from the pleading. What the pleaded it's there.
This has nothing to do with the outcome of this matter, but the arbitrator, was he a commercial person or a judge or what?
Well, they were all counsel.
Counsel.
One is a judge.
Well, yes.
One is a judge. One is a retired judge of the Singapore court, if I'm not wrong.
Not a retired judge, my Lord. They have a practice of co-opting judges on the bench. And then you can come back and you can start practice. It's like the English court also, they have additional judges. Members from the bar are invited to the bench as additional judges. They serve for a fixed term of 2 years. Then they can go back to practice and plead in the same.
Nothing to do with it.
That has nothing to do.
Just a curiosity.
Yes. So all counsel, my Lord, and partner of a law firm, in fact. The presiding arbitrator was partner of a law firm of Singapore.
Yes.
So, my Lord, this 372 first line, my Lord.
This appears to be argumentative, sort of. I mean, that's why I asked.
Yes. Yes, because they're all practicing counsel.
When judges become judges from practice,
see.
I mean, we are more argumentative than people who come from service.
I see.
But we are Indians, so we have to be.
Better.
Anyway, Mr. Thakur, let us continue. I'm digressing.
It's a 372 first statement itself.
Yes.
Goes to the root of the matter. The tribunal disbelieves the basis of assessment of damages, then with the greatest of respect, the claim for damages must fail. But here it doesn't fail, it goes up more than.
Should have stopped here.
Should have stopped here. Goes up 10 times. From 1.7 skyrockets to 150. Then, my Lord, kindly see. What was the damage claim? The damages claimed is the loss suffered by UpHealth Inc. and not the claimant. So this deconsolidation, I'll tell you, Lordship, what is in one line, if I may summarize. The locale was to consolidate with the claimant. because they would have a consolidated balance sheet. Glocal would become the wholly owned subsidiary of the claimant, which is Uphealth Holding Inc. Uphealth Holdings Inc. is the claimant. So the revenue of Glocal would be reflected as a revenue of the claimant, which is Uphealth Holding Inc., which would result in the increase in the share value of Uphealth Holding Inc., the claimant. So the basis of the claim is that therefore my parent, Uphealth Inc.'s shareholding would also increase, because he would take benefit from the ultimate, he would be the ultimate beneficiary of the subsidiary coming into the claimant. So that was the basis. And now they had to deconsolidate it because the control from Glocal did not come into control. So that was the basis of this deconsolidation loss of 1 point. And this is the only basis. The tribunal also says this. So he says now the damages claimed is the loss suffered by Uphealth Inc. and not the claimant. You have not suffered any loss. Your parent would have suffered a loss. You could not have claimed a loss. Kindly see the finding. The damages claimed is the loss suffered by Uphealth Inc. and not the claimant. So the matter ends here. You have a misconceived claim for damages. These entities are not one and the same. Very correct. Further, the market conditions where Uphealth Inc. is listed, that is New York, and the market's previous concerns regarding Uphealth Inc. may not accurately represent the loss suffered by the claimant being deprived control. This is where the date change comes in. We'll elaborate on this later. This last sentence has to be with the date change. Your Lordship had seen earlier, market had absorbed the knowledge, etc. This is all that. But it's irrelevant for our purposes. Your claim for damages is misconceived according to the tribunal. The matter has to end there. The tribunal cannot go and make out a claim. Now, my lord, kindly sees next paragraph. Now he goes into, with the greatest of respect, the matter should have ended here. He cannot go into the assessment of evidence at all now any further. Now he undertakes the exercise of assessment of evidence on quantification of damages. In the circumstances, the tribunal is in principle satisfied with Professor Len's approach to the calculation of damages from 26 September 22, that is the range of $70 million low scenario to $150 million high scenario, with a midpoint of $110 million mid scenario. However, there remain several imponderables in the assessment of damages. Then he says these are the factors which need to be concerned. And kindly see B. It is unclear. Kindly see B. It is unclear whether the claimant would have been able to secure the additional debt financing from ICICI Bank. So if this is an imponderable which the tribunal itself notices, without any certainty of any debt coming in, then, and the debt was required to implement McKinsey report. And I am saying myself, I don't know whether I would have got the money or not.
So how does he
How
resolve?
does he give? Nothing. And so he says that after noticing these imponderables, now can we see 375?
Yes,
In
tempered.
these circumstances, the relief to be granted has to be tempered to take into account these considerations. With the greatest of respect, this is perverse. If the money doesn't come in, there's no question of reducing the quantum. He uses these imponderables to drive down the amount. But the primary test is whether any amount would have been made at all or not if these imponderables had not been satisfied. You can't put the cart before the horse.
Don't you feel a doubt every time you say this? Whether it's the horse or the cart, which
No.
putting the horse before the cart. Every time I tend
no,
to
the
say
trick-
horse before the cart and
No.
then just check.
That is why I took a pause, man.
Yes, that's why I asked you.
Yes.
It happens to me every day. I take a pause and yes, would it be
Which
the
is the
cart
one?
or
That is why I took a pause. So, my
by
lord,
pronouncing irretrievable breakdown of marriage. That's has been a sticking point since my starting days of irretrievable breakdown of marriage. Say that 10 times and I'll give you the award. This award. Yes.
so, my lord, kindly see
Yes,
B,
right.
the imponderable. So I
So the
stopped at one.
imponderables, according to you, should have hit the very basis of the claim itself,
It's the claim.
not the quantum.
I mean, at the basis of the claim made out by the tribunal again, not the basis of the claimant's claim. Even the tribunal in its wisdom made out a new case, but even the new case made out by the tribunal cannot succeed because of the imponderables. There are too many. That is, I said, it's a problematic award. What conditions would have been attached to the debt financing? Very correct. That is what I told your lordship first, whether sanction.
But he's very accurate in
Yes, imponderables, because
putting
he's a
a-
trained lawyer.
Imponderables are actually that.
Yes, he correctly identifies.
Identified.
And then kindly see the third. What implications these factors may have had on the company's ability to implement McKinsey? Absolutely correctly identified. 1 and 2. If 1 and 2 are not satisfied, then 3 cannot happen. Now I am posing myself a question, my lord. How do you reduce the quantum if you are not satisfied, if you are yourself not satisfied that 1 is a 100% granted? It's not a question of reducing quantum. It's a question of event.
It hits at the very basis of the
Yes.
claim.
This whole assessment, my lord, is flawed.
How does he goes about tempering?
Now, my lord, kindly see tempers, he just reduces.
Achha.
Kindly turn over to now, kindly it makes it even better. 376, 377 is all the narration of what happened in the past. Then kindly come to 378. In the circumstances, in addition to the tribunal's order, which would result in the claimant receiving actual control of the company. This is a specific relief decree. As the primary damages, the tribunal awards the claimant a sum of $29.5 million, which is the primary damages. Now, this primary damages, how it comes, we don't know. Analysis is later. Now, kindly see primary damage. This sum is representative of the damages already suffered by the claimant by being deprived of actual control of the company from the date of loss to the date of this award. The said sum has been calculated using the present value of cash flow in the mid scenario for 2022 to 2024 calculated by Professor Len. It is the tribunal's view that if the respondents provided the claimant with control of the company together with all the assets provided for or as contemplated by the SPA before 30th September 2024, the claimant should not be entitled to the further and full damages calculated by Professor Len, since the claimant would be in a position to obtain a return of investment in the future. So this is all return on investment. And your lordship will see 482, the footnote. This 30th September date now comes from the tribunal. It's nowhere in the pleading. This cutoff date of 30th September, your lordship sees in the 5th line at page 557.
This September is there in the agreement itself somewhere. 30th September was the date of handing over.
No. Kindly see 482.
Yes.
The footnote. The 30th September 2024 has been settled on as the cutoff date to allow the respondents sufficient time to comply with all the necessary procedures and registrations to effect a proper handover of the company's operations and actual control thereof to the claimant. This is the tribunal.
So wasn't 30th September the cutoff date for handing over control of the company?
If I may just the leave of my senior, 30th September, as per the awards dispositive part, is when they are supposed to hand over
the control.
company. If they fail,
That was the cutoff date, yes. After
if
that.
they fail, then I have more.
Yes.
That is what's.
My learned friend is absolutely correct. But that is
my-
not the date given in the contract. This is a date fixed by the tribunal
itself. Yes.
itself.
All right.
Your lordship's query, if I understood your lordship, was this a date given in the contract for completing handover and takeover? It was not.
I saw it somewhere, 30th
Yes,
September.
because
in
it's
the
in the
dispositive part.
yes.
Is right. You're right. Thank you.
So, this is a date which the tribunal says that I'm making the award on this date. This, according to me, is a sufficient time for handover. So, but this is not what the claimant's pleaded case was. Now, he says that this is what Len has calculated, present value, and Len's calculation is all on McKinsey and all on these imponderables. Len doesn't do any rocket science. He says McKinsey says this, McKinsey would have resulted in this, but the tribunal itself notes the foundational weakness. It's like the crack in the foundation, the imponderables.
Yes.
Then Malad kindly sees next 379, very important. So this is one limb of the matter, Malad. The assessment of primary damages beyond what is claimed, contrary to pleading, and beyond the pleaded case. I'm sorry. Beyond pleaded case. 379. 379. 379. 379. 379. 379. 379. 379. 379. 379. 379. 379. 379. 379. 379. 379. 379. 379. 379. 379. 379. 379. 379. 379. 379. 379. 379. 379. 379. 379. 379. 379. 379. 379. 379. 379. 379. 379. 379. 379. 379. 379. 379. 379. 379. 379. 379. 379. 379. 379. 379. 379. 379. 379. 379. 379. 379. 379. 379. 379. 379. 379. 379. 379. 379. 379. 379. 379. 379. 379. 379. 379. 379. 379. 379. 379. 379. 379. 379. 379. 379. 379. 379. 379. 379. 379. 379. 379. 379. 379. 379. 379. 3 Contrary to the pleaded case, because it's a new case made out by the tribunal. In excess of relief sought, and no evidence, not supported by any evidence on record. From the basis of the award itself, on a plain reading of the award, without troubling your lordship with the voluminous pleadings which were filed, on the basis of the tribunal's own appreciation of evidence, on the basis of this evidence, the result is perverse. Otherwise, I would have to take your lordship through all the volumes to show that, see, there is no evidence, my lord. But tribunal has culled out whatever evidence was there. This is the best possible evidence according to the tribunal.
This is the premise of the award.
Yes, this is the whole premise. Then, my lord, kindly see so this is one limb. The damages in addition to specific performance. Now, kindly see the damages in lieu of specific performance. Now, kindly see 379. The question also arises, what relief would the claimant be entitled to in the event the respondents fail to hand over actual control of the company with all of the assets provided for and or contemplated by the SPA on or before 30th September 2024? Pausing here for a minute, my lord. This question does not arise from the pleadings. There is no prayer for damages in lieu of specific performance. This question does not arise. And the tribunal has advisedly not referred to any relief para of the pleading as they have done in the past, 463.3, 463.4. Nothing here, because there is no such pleading. There is no such relief. And he admits it. It is noted that the claimant has not provided for such a scenario. This is like rubbing salt. But rather has sought and calculated damages on the basis that it would not receive control of the company. Now, not, my lord, is perhaps a typographical error, because otherwise it doesn't make sense. Let us give him that much, my lord. It is noted that the claimant has not provided for such a scenario, that is a scenario if he doesn't get control of the company, which is noticed in the first sentence, but rather has sought and calculated damages on the basis that it would not receive control of the company. This not is perhaps a typographical error, but if they say it is correct, then it's up to them.
No, it may be correct. Question is entitled to in the event they fail to hand over. What relief would the claimant be entitled to in the event of not fail to hand over?
Yes, this is what is not claimed. He's saying that if the claim
that has not provided for such a scenario, that is not handing over. Achha, contradictory.
So not has to be a typographical, my lord, read together with the first sentence.
Yes, it would be contradictory.
Yes, it would be contradictory. And it would be contrary to the claims which are there on record.
It is already.
Yes. So, my lord, now the tribunal determines, kindly see, my lord, the tribunal determines that the claimant is thereafter entitled, in addition to the primary damages, to the damages assessed by the tribunal in paragraph 382 below, additional damages for permanent loss of actual control of the company. This is again, he's traveling outside his jurisdiction. There's no, he says in 379 first sentence that this claim has not been made. This claim is not to be found, he says in 379 first sentence. And then he undertakes upon himself this exercise. And this claim is actually not there. What he says in 379 first sentence is not wrong, because I've shown your lordship what the claims were. Then how could he have, in the greatest of respect, my lord, undertaken this exercise at the first instance? This is traveling outside jurisdiction. This is malice in law. This is, my lord, the first limb of my submission, grant of reliefs beyond pleadings. This is the second part of his additional claim, is squarely this. The money award which the respondents now seek to execute is this. Primary damages, I've shown your lordship why, in my respectful submission, it cannot be. And additional damages is squarely contrary to natural justice. You don't make a claim, it's violation of natural justice. The only thing that the tribunal is required to do is act in accordance with natural justice and within its four corners. of its jurisdiction, which comes from the
If
pleading.
it's beyond the claim, then it would be beyond the subject matter which came up for
Yes.
consideration.
And my lord, and your lordships have held that if you grant a relief which is not prayed for, that is beyond natural justice also, because you're not giving the other side an opportunity to react with it. React to it. I'm not even put to notice that this kind of a claim is staring at me in an arbitration which is conducted
Taken by surprise at the award stage.
at the award stage. It hits me at the award. It's not there in the claim. I choose not to contest a proceeding, my lord. I kindly see a situation. I choose not to contest a proceeding for whatever reasons. But I see that the worst that can happen to me is this. I'm mentally prepared for this. Comes as a total out of the blue.
Obviously.
And this is hit by natural justice. Your lordships have held that this is violation of natural justice. It is in excess of jurisdiction, claims awarded without pleadings in excess. He has wandered outside the limits of the claim. And then it's hit by a violation of natural justice, which goes to the root of the matter.
Yes.
Then kindly see 382. Now how he quantifies this additional. Now it's 382 is on quantification. The tribunal determines in the round the additional damages for permanent loss of actual control to be awarded to a sum of $80.7 million, taking into account, kindly see, taking into consideration the imponderables that cannot be accurately calculated and are projected. The greatest of respect, it's not a question of calculation. It's a question of happening. The loan being sanctioned first, the conditions of sanction, and third, one thing he missed out with his trained legal mind was, what was the amount of loan which would be sanctioned? Whether 20 million or 5 million? With the 5 million loan, could you have carried out the McKinsey projections? How much of the McKinsey projections could you have carried out with 5 million loan? It's melodic. When we talk of imponderables, then there's too many imponderables. The permutation and combinations are unlimited. Even if a loan was sanctioned, my lord, and the loan imposed a condition that you have to mortgage 50 hospitals, and I am not willing to mortgage 50, I mortgage only 3.
There are so many variables.
So many variables. And it's not it's not a question of calculation or projection. It's a question of the certainty of the loan being granted. Everything hinges on that. That is his evidence. I didn't have money. My big company, listed company, Uphealth Inc. also did not have the money. It was to come from a loan, which I would have taken by mortgaging the target company's assets had I come into control of the target company. Everything is, this is the whole sum and substance of the case. Stripped of all these, my lord, verbose award. So, my lord, the sum of $80.7 million has been calculated by deducting the primary damages from the myth scenario damage amount to myth scenario damages amounting to $110.2 million calculated by Professor Len. In the tribunal's view, it is more appropriate in the circumstances to adopt the myth scenario proposed by Professor Len as opposed to the high or low scenario after our careful consideration of the imponderables discussed in this section. It is perverse. There is no consideration of the imponderables. The imponderables, kindly bear with me, imponderables discussion would have mean that I find that there is documentary evidence that this loan of ICICI would have been sanctioned. It is a certainty. Yes. There is no documentary evidence of ICICI loan coming. He just says, I met with an ICICI bank manager. Who was that bank manager? Whether he at all had the authority to sanction a loan of $20 million. These were the questions which the tribunal should have put to the witness. And he just takes ipse dixit the witness's witness statement and said, yes, you met a bank manager on your trips to India. Well, what was the authority of the gentleman whom you met? Did he have the sanctioning authority of a 20 million loan?
An actual in-principle sanction might have helped them.
Might have helped them. And yes, I'm grateful, Malad. And in principle sanction, setting out the terms and conditions of the loan, then they would have to show that, yes, these terms and conditions I was able to fulfill.
Very well.
Yes. Which would have then given me a loan for certain.
Which would be an objective standard of calculating.
Great. Which would be an objective standard of assessment of evidence. Now, calculating damages would come later with the greater assessment of evidence that damages would have been suffered. And then would come the quantum of quantification. Then lens theory would have come into play. But whether damages would have been suffered or not, this is failing, my lord, at the first test. Then, my lord, kindly sees. So he talks about consideration of imponderables, but he doesn't. If the claimant elects, now, my lord, kindly sees. If the claimant elects to receive the additional damages, the total damages it receives would amount to US $110.2 million. The tribunal finds that the said sum of US $110.2 million to be a reasonable estimate of the loss suffered by the claimant due to the lack of actual control over the company arising from the breaches of respondent numbers 2 and 6. In this circumstance, the fact that Len has not considered the value of receiving the company in the future is not an issue, since the claimant would have it. So this is, my lord, his estimate of loss. Len based on McKinsey, McKinsey based on finance, finance is an imponderable. Now, my lord, kindly may I need note further how he justifies this amount. The tribunal notes that in its amended claim, the claimant sought a sum of US $1.7 million or such other amount as the tribunal may determine to be appropriate as damages arising from the breach of contract. Subsequently, as discussed above, the claimant provided Professor Len's 3 estimate of damages arising from breach of contract. The tribunal is empowered to determine the appropriate sum of damages. The claimant has clearly set out its case for loss of actual control arising from the respondent's breach of contract and sufficiently articulated the fact that led to its lack of actual control over Glocal in its SOC and in its witness statement. So facts are pleaded, the claim is not pleaded. So on the basis of the pleaded facts, I will ascertain the measure of damages. This is what the tribunal says. And on a 10 times higher side. In the tribunal's view, it is plain that it is the respondents acting in concert to breach their obligation on the SPA to promptly hand over actuals. So this is, let us take this to be correct. But even if I am the biggest wrongdoer, can I be penalized in this manner is the question. This is his assessment of damages. Now, my lord, this sentence, your lordship will kindly note, my lord, the claimant has clearly set out its case for loss up to witness statement. That is an admission that the tribunal has established the claim for damages apart from the basis which the claimant had. This is the justification which is being offered here in the context of the claim for 1.7 was deconsolidation. He says, I'm not going to award you for deconsolidation, but from the other surrounding pleadings which are there, I'm going to award you a higher damages. This is not the pleaded case of the claimant. The claimant has clearly set out its case for loss of actual control and sufficiently articulated the facts that led to its loss of actual control over Glocal in its SOC and written statement. So on the basis of the fact that I have loss of control, I estimate damages at a separate footing. That is his pleading. That is the award. That is the rationale. Now, I'm going to kindly have yes. The claimant's pleadings on this, my lord, are noticed in heading D at page 525. The summary is there in the award. It sets out this at detail at 525. In this assessment. Can you see 525, please, my lord, paragraph 307. The claimant's position, ordering respondent so-and-so to pay damages to Uphealth Holdings in the sum of US $1.7. This is the case. The claimant's position is that the respondent prevented the claimant from appointing its designees to the board, as a result of which the claimant was deprived of actual control of the company and suffered damages. The claimant argues that. Now, this is the supporting facts which your lordship found there. These are the supporting facts. I'm taking your lordship the other way around to show your lordship how this whole thing is worked out. All those, and this is the claimant's argument. So all this is, my lord, convening a meeting of the board and appointing the claimant's designees as directors to the board. Then B is, as the respondents never complied with their contractual obligation to give claimant control of the company in the first place, there is no date on which claimant can be said to have lost control of the company. The question is not when the claimant lost control of the company, but rather it is when the respondents repudiated their obligation to cede control of the company to the claimant. That date is 15th February 2022. This was the claimant's argued case. Pleaded case, sorry, my lord. That date is 15th February 2022 because by that date, the respondents had made clear that they would not convene a meeting of the board to pass resolutions appointing the claimant's designees to the board as required by so-and-so of the original SPA. They had also repudiated their obligation under clause 12 to take all action necessary to give effect to the original SPA as amended, that is to hand over control of the company. Now, according to Mr. Beck, February 22 also marked the end of a period of months during which the claimant attempted to engage with Dr. Azim, who was the promoter of the target company, respondent 2, to appoint its designees to the board, and Dr. Azim signaled that he would not facilitate UpHealth Holdings appointments of its designees to the global board. The events after 15th February generally fall into two categories. Now, on 15th February, kindly come to E, my lord, which is very important. On 15th February 2022, McKinsey issued its report to UpHealth Inc., recommending business improvement initiatives of UpHealth Inc. and its subsidiaries. Now, this is a parent company, not the claimant. In May 2022, Global Healthcare abruptly and without explanation revoked claimant's access to Global Healthcare's email server when claimant urgently needed that access to comply with the SEC subpoena. As Dr. Azim and this is the stock exchange subpoena, as Dr. Azim and Mrs. Azim had repeatedly been informed. By the end of June 22, respondents had essentially become unresponsive to McKinsey's attempts to engage with them regarding the business improvements McKinsey had recommended for the company. Before the meeting, claimant requested the votes to authorize the appointment of claimant's designees be taken according to the number of shares. Claimant again requested a vote by poll at EGM. Had Dr. Azim, as chairman of the Global board, complied with that respects as he was obligated to under Indian law, claimant's designees would have been appointed. But claimant had a supermajority of shares of Global. Azim ignored and called for a vote on the resolution by show of hands. When these events are considered together, it is apparent that none of them can fairly be described as a point when claimant lost control over Global that it had been able to exercise previously. Rather, these events constitute an unbroken series of challenges to claimant's efforts to exercise control, growing in intensity over time as claimant was forced to take further steps to enforce its rights. All these events are consistent with the position expressed by Azim in February 22 that the Global board would not facilitate the appointment of claimant's nominees, and the establishment by the respondent back in 20 was a category of shoulders, so and so. Then this is all this case. The claimant also asserts that 15th February 22 is the date when the claimant incurred losses. Now, kindly see, this is his pleading. Claimant also asserts that February 15, 22 is the date when the claimant incurred losses on account of not having actual control of that company. By that date, as described above, the respondents had repudiated their contractual promise to give actual control of Global Healthcare to claimant.
So this date should have been the basis.
This is the pleaded.
This 30th September 2024.
No, 26th.
Sorry, 26th September.
Yes, 2022.
What was the page? Yes.
Para 361 at page 549. Actual date of breach and loss is the date of EGM, that is 26 September.
Yes.
This is the tribunal's assessment.
Yes.
The claimant's pleaded case is 15th February 22. Then kindly see how it has, and as the record makes clear, claimant did, kindly come back to 308, please, if I come back. And as the record makes clear, claimant did not have actual control of the company at any point after 15th February 2022, even though it had notional legal control, because being the supermajority shareholder according to him, but I didn't have control of the board. The losses the claimant began to incur after 15th February 22 are the additional revenues Global Healthcare would likely have earned if it had implemented the business improvement initiatives circulated by McKinsey on that day. So had I come into control, McKinsey.
How did it make a difference if 26 September was taken?
Yes, I'll tell you, Lordship, why.
Acha,
Yes, it comes, my lord. Yes, that is an element of fraud, my lord.
yes.
Mr. Beck testified that the business improvement initiatives led to the RAP scenario were realistic for local healthcare at that time. The revenues McKinsey attached to them were broadly consistent with the revenues Needham had projected for local healthcare before the original SPA was signed, and Uphealth Inc., that is a parent company, was prepared to devote considerable resources to putting those initiatives into practice. Now, I'll kindly bear this in mind with the evidence which comes later. Uphealth Inc. was not putting in a penny. $20 million loan was coming in from ICICI. $5.5 million was paid to the company as terms of the SPA, which were used to pay off the existing debt, make the assets debt-free. Then those debt-free assets would then be mortgaged to ICICI Bank to raise another 20 million. So it is not of Uphealth Inc. The pleaded case, can you see how the narration changes from the pleadings to the evidence? The reason why local healthcare did not earn the additional revenues projected in McKinsey's RAP scenario is that the respondents did not cooperate with McKinsey or Uphealth Inc. in implementing McKinsey's business improvement initiatives. If the claimant had been able to exercise actual control over local healthcare, the respondents would not have been able to prevent the initiative from being implemented and the gains in the RAP scenario from being. So these are all business profits. I would have come in, I would have made this much profit. Professor Len has calculated claimant's loss from the actual control of the company to be 80, and this your lordship has seen. Having carefully considered the evidence and submission before it, the tribunal determines that the respondent numbers 2 to 6 have breached the SPA as a result of the claimant having been denied actual control of the company, resulting in losses. And then, my lord, 311 is his findings on breach, which I'm not troubling your lordship with. Then kindly come to 312. The claimant's case is that they suffered loss due to a lack of control and not a loss of control, since they were actually not in control. This case is compelling. There is no evidence on record to show that the claimant was in control of the company. Rather, the claimant continually relied on Dr. Azim to provide information regarding the company, have failed to give access to the company. And then, my lord, after this assessment of pleading comes the assessment of damages 313, which I showed you. Now, see, now kindly appreciate, my lord, the assessment of damages as compared with the assessment of damages as compared from the pleadings in D. I now in my submissions, my lord, I put the cart before the horse. I put the cart before the horse.
Probably this was the premise, I mean, mistaken or otherwise, of the tribunal, because they say that since the respondents did not cooperate with McKinsey or Uphealth
Yes.
Incorporated in implementing McKinsey's business improvement initiative,
Yes.
so that was probably taken as a premise by the
Yes.
tribunal.
Yes.
If these they could have implemented these initiatives.
Yes. But implemented these initiatives provided the imponderables became certainties.
Yes, but he himself holds that those are imponderables also.
Yes.
That's also important.
And he only gives the discounting in the quantum of claim.
Quantum, yes.
He doesn't say with any degree of certainty that these imponderables are no longer imponderables but are certainties because of XYZ reasons. That is not there.
True.
So this is where, Mela, there's this reasoning on damages is perverse, not primarily because it is beyond the pleaded case, admittedly beyond the pleadings now, admittedly beyond relief sought. New case made out by the tribunal in the course of arguments and witness action. So pleadings, now I've shown your lordship what the pleaded was. Your lordship has now seen how the assessment takes place, appreciation of the pleaded case. It's totally contrary. Now, my lord, so this is on the first part of it. Then comes the second part of it. Could the tribunal, even if I assuming but not admitting that the tribunal can award damages in lieu of specific performance in the absence of any pleading? It cannot, because that is what the section itself says, section 21, and this was a Indian law. Your lordship will find the award is replete with references to Indian law. Then, my lord, the law, as I understand, my lord, is, with all humility, is decree for specific performance with damages, no difficulty. Decree for specific performance without damages, but in course of reference, the tribunal finds that damages should be awarded in addition to specific performance, because only specific performance will not do justice, then the claimant must amend his pleading. Without amendment of pleading, also damages cannot be granted. And third, my lord, damages in lieu of specific performance. You start with a claim of specific performance and then you say damages in lieu of specific performance, then the tribunal can grant you damages in lieu of specific.
Yes.
In the absence of a prayer for damages in lieu of specific performance at the outset or post amendment, tribunal cannot grant in lieu of specific performance. But my lord, what he has done here is specific performance and damages in lieu of specific performance at the same time in the same award, and he gives the claimant an opportunity to elect and the respondent an opportunity to elect as to whether to comply with the decree for specific performance. This is the absurdity. Then what is the worth of a decree? If it is to be executed at the whims and fancies, if it is to be executable at the whims and fancies of the respondent, then there's no decree for specific performance in the first place. The disposition says, my lord, by 30th of September, the respondent should hand over. If the respondent offers to hand over at 30th of September, then the claimant has an option to elect whether he will take that handover or not. So two variables in the decree for specific performance itself. And then he says, if the respondents don't hand over or the claimant elects not to take over in spite of the respondent's offer to hand over, I will give them damages in lieu of specific performance, which is 110 million.
It's a contingent sort of award.
Yes.
And
But that election has to take place at the stage of either at the stage of pleadings or at the highest at the stage of trial. Not after that, not after the award is made. This is an election taking place after award.
that's why it's a contingent award. I mean,
Yes, so
contingent award in the sense that if this happens, that will not happen. It may happen.
But
Uncertain events.
Which is unknown in the greatest of respect under the Specific Relief Act. Specific Relief Act is not a complete code, I understand. But
But if a claim is made under that act,
this is a claim for specific performance of a shareholders agreement. Shares, my lord, are defined under the Sale of Goods Act as movables. Shares are defined under the Sale of Goods Act 2D, if I'm not wrong, the Sale of Goods Act as movables.
yes, yes.
And this is a specific performance for movables, which are not easily available in the market. This is the classic, simple classic case. It's a regular case which we do, Malad. It's nothing unusual. Specific performance of share purchase agreement, not share purchase of Reliance shares. That will never be awarded. Because there's a measure of damages. I had an agreement to buy at 10 rupees. Delivery date is 1st of January. You did not sell to me on 1st of January at 10 rupees. The market price was 12 rupees, 2 rupees. This is simple. But this is shares which are not available in the market. So therefore, specific performance. And there's no difficulty. I'll just check, my lord, on the shares part. I said the wrong section, but I'll just check. Anyway, so my lord, this is a decree for specific performance which provides for election after the decree is made. Is, my lord, unheard of. The greatest. There are decrees for specific performance, my lord, which are conditional upon events which are outside the control of parties. That is, in such and such date, the clearance from the income tax department will be obtained. If it is not granted,
yes,
money will be refunded with interest. Urban land clearance will be obtained. If not granted, money will be refunded. But not a decree which says that the claimant will not, if the claimant does not take steps to obtain the clearance, he will just pay damages.
Cannot be left to the election of the parties.
Yes, my lord, grateful. Cannot be left to the election. The election has to take place at the stage of the trial, at the latest. Kindly, may I trouble your lordship, 21 of the Specific Relief Act.
I think. তুলে দেখুন না
Lordship has 21. Because we are now concerned with this award of damages.
Yes.
Not with so much the grant of specific relief, not the award of damages.
Hmm.
In a suit for specific performance of a contract, the plaintiff may also claim compensation for its breach in addition to such specific performance. So this is at the filing of plaint stage.
Yes.
In addition, which is 463.4 in our case. If in any such suit, the court decides that specific performance ought not to be granted, but that there is a contract between the parties which has been broken by the defendant, and the plaintiff is entitled to compensation for that breach, it shall award him such compensation accordingly. If in any such suit, the court decides that specific performance ought to be granted, but that it is not sufficient to satisfy the justice of the case, and that some compensation for breach of the contract should also be made to the plaintiff, it shall award him such compensation accordingly.
But this is not dependent on pleading.
This is not dependent on pleading. The court decides. Now, but kindly see 5. In determining the amount of compensation awarded under this section, the court shall be guided by the principles specified in section 73 of the Act of Law.
Of course.
Next, kindly see. No compensation shall be awarded under this section unless the plaintiff has claimed such compensation in the plaint. So, my lord, so one is dependent on 5. The pleading has to be there. Now, for 3, yes, the proviso comes in. Provided that where the plaintiff has not claimed any such compensation in the plaint, the court shall at any stage of the proceeding allow him to amend the plaint on such terms as may be just for including a claim for such compensation. No compensation shall be awarded unless there's a pleading to that effect. And my lord, what your lordship is considering is 3. That is
then qualified by 5.
3 is qualified by 5 in the first case, but that is perhaps not.
Proviso is universal for
yes, all claims of compensation.
That's universal.
It's
1,
universal.
3, whatever.
Yes, my lord. And we are not in our case concerned with 3, because 3 is in all the court decides ought to be granted. So this is again damages for breach in addition to specific performance. This is not
he is granting in lieu of.
Correct. So my lord, we are not concerned with a 3 situation to be. We are not concerned with a 3 situation.
Yes, right.
He is granting in lieu of
2.
Yes, 2. And we are not even with 2, because he says specific performance he is granted. 2 is a specific performance is not granted. There is a contract, but I will not grant you specific performance for various reasons.
Oh, yes.
Yes.
It grants both.
Yeah. It's not 2 also.
Yes.
So Manadai, it's the law is very clear. You cannot have both at the same time. You cannot have specific performance and damages in lieu of specific performance at the same in the award stage. In the award you cannot have. In your pleadings, yes, of course you can have, but not when an award is made. In the course of trial, of course you can have. You bring in an amended. You bring in an amendment.
No, in the claim, the plaintiff, this claimant did not.
In our claim. In our claim.
In your claim.
Yes.
The claimant did not claim specific purpose of a contract, or this is in addition to.
Yes. 463.
In the alternative, did he claim for damages if specific performance is not granted?
No. Kindly come back to the claim. No. Damages in lieu of specific performance was not claimed. Kindly come back to the amended pleadings, amended claim.
Yes.
Kindly come to page. Page where he set out the amended claim. Para ya page? Para bol.
Page 483.
Page 482. Thank you. Starts at para 208 at page 483.
Yes.
at 4. Subsequently, on 5th August 2023, the claimant amended the relief sought for as follows. Kindly go through the relief, please, my lord. 463.1 declaring that they hold these shares.
So issuing a mandate so 463.3 onwards, it is specific performance.
Yeah, 463.1 and 463.2 are declarations.
Yes. Oh,
so
mandatory injunction, permanent mandatory.
That is, my lord,
463.3.
yes, so my lord,
1 and 2, yes,
declaration, declaratory reliefs,
is permanent injunction, that is the specific
that is
performance.
the specific performance, no difficulty. My lord, 463.3.
In the
Then
alternative
kindly
case.
turn over to 463.4. Ordering the respondents to jointly and severally pay damages in the amount of $1.7 million arise or such other amount arising from these respondents' breach of contract. So this is damages in addition to specific performance. Giving him the benefit of doubt, my lord.
No, alternative has to be there.
Alternative has to
I
be
cannot give the benefit of doubt.
It's addition.
Addition has to be.
My lord, this is what the tribunal also understood. I'll show you, lordship. My lord. The tribunal also understood that there's no prayer. Ordering respondents to pay for fraud and misrepresentation, 463.4 and 463.4.
Unless it is in alternative, in the alternative also it was doubtful previously because
Yes.
specific performance cannot be granted if
there's an
it
alternative.
lies in damages. But that has been now
Model.
tempered down, yes. Like the tribunal have tempered it down, and in the alternative you can.
I recently came across a case where it said, Mr. Chadda pointed out, the reliefs were
Yes.
specific performance, and prayer B was, if specific performance is rejected, give me so much in damages. The tribunal said, the court set aside the award, said if specific performance is rejected, then you cannot get in lieu of specific performance damages. If specific performance is rejected, then you cannot get damages in lieu of specific performance.
Yes, in lieu of means
In lieu cannot
had
be.
to be in the first place.
Yes. So
yes.
So
the language here is also decides that specific ought not to be granted.
Yes. That means, my lord, you are otherwise entitled to.
But there is a breach.
Yes.
Contract which has been broken.
Yes. So there is a breach is the first limb.
Breach has to be there.
Breach is there. Then you are entitled to specific performance, but for various factors which the court says.
But Mr. Thakur, why can't that be granted if the breach is established?
Yes.
Why can't I say if even if specific performance is rejected, not granted, I mean,
Yes.
can be read
Remember, damages in lieu of specific performance means that you are entitled to specific performance.
The language of 21(2) is if in any such suit, the court decides that specific performance ought not to be granted, then the basis is thereafter.
Yes.
But that there is a contract between the parties which has been broken by the defendant. So if in that case, there was a breach of contract established,
yes,
and court rejects, which rejection may come within ought not to be granted.
Yes.
So why can't I say that if there is a breach, if the breach is established, even if you reject specific performance, grant me in lieu.
Damage. You grant me damages.
Yes.
In lieu of specific performance.
Yes.
It is not just an equitable to grant specific performance.
It's covered by 2. The broader connotation of 2 is 2. You only have to establish a breach of contract.
Yes. But
specific performance granted or not granted, then it's all right. It matter ends. If it's not granted, here it says ought not to be granted, court feels. Rejection is also one of those, it's a species of that. Why can't it be called a species of rejection? Rejected because the court feels it ought not to be granted. Then what does it do? It rejects.
Yes.
And if there's a breach established,
yes,
then under 2 it can in the alternative.
So there's a slight difference there. Kindly permit me. Other than the fact that
in the language, maybe.
Yes. My lord, what your lordship is considering is that damages as an alternative to specific performance.
I say that rejection of specific performance is one of the species of the genus court feels it ought not to grant specific performance. Ought not to be on various reasons, discretionary, otherwise entitled, but I don't grant for this. Or it rejects. Ultimately, it rejects. Ought not to be granted means rejection. So it rejects the pair of specific performance.
Yes.
But still grant in lieu of specific performance this
damages. Provided there's a claim for damages.
No, not in your case. In that, the one which you came across.
So, my lord, there the distinction.
Why should you say that? I mean,
yes, why the distinction was that the prayer specifically says if my claim is rejected, grant me damages.
Yes, that if I still establish breach of contract.
If I, yes. So, my
valid prayer.
No, so I'll place that judgment also. Here, my lord, what is relevant in 21.2 is the specific performance ought not to be granted is that you are otherwise entitled to specific performance. The rejection is not that you're not, what do you say, my lord?
What does the court feel? What does the court do if it decides that specific performance ought not to be granted?
If the court,
What does it do with the prayer for specific performance?
the court decides that specific performance ought not to be
I feel court feels it ought not to be, decides it ought not to be granted.
granted, yes.
What does it do with that prayer? Specific performance.
Rejects the prayer.
That is what I'm saying.
Yes.
Therefore, I say rejection is a species of the decision of the court ought not to
Ought
be
to
granted.
grant.
Ought not to be granted maybe of 2-3 criteria.
Yes.
It otherwise ought to have been granted, but because of this conduct or on equitable principles, I am not granting. So
Or the
then
contract is not specifically enforceable.
yes, enforceable. Yes.
It's not enforceable in nature. You've claimed specific performance, it's not enforceable in nature.
Yes.
The prayer for specific performance is rejected.
Yes. It cannot be specifically granted because suppose it cannot be
Land
performed.
prices have gone high.
Impossibility.
Impossibility.
May
Yes.
be one of the grounds.
Yes.
So ultimately it rejects the prayer for specific purpose.
Yes. Impossibility, then you can't get damages. Man. It becomes impossible.
Yes. Then it cannot.
It can only be, my lord, if the party makes it impossible.
Yes.
I go and sell it off to somebody.
Right.
He mortgages it with
Right,
somebody.
right.
So that, but my lord, in our case,
Anyway, let us
the
forget that.
damages in lieu of specific performance was not claimed. Your lordship has now
Then
said
it was not claimed.
it was claimed. And my lord, the tribunal takes note of this. Kindly come back to once, my lord, 379. Para 379 at page 557.
Yes, yes.
It is this the not paragraph, my lord. It is noted that the claimant has not provided for such a scenario, that it doesn't come into control. The claimant always wanted control. So the claimant proceeded on the basis that if I get an award for specific performance, I will compel specific performance in the manner which is known to law by levying execution. So this in lieu of damages prayer was not made. And 21 says no claim for compensation, no relief for compensation will be granted unless it is founded in the plaint.
Yes.
And for that you are, and so my lord, the law, the legislature is alive to the fact that somebody might start with a claim for specific, but in the course of trial he might become wiser and want to bring in a alternative or an additional damages.
Like if the court feels under
Court feels, yes.
decides that
Yes.
it won't grant, then
Yes.
it can,
Can amend.
allow the prayer. But what the tribunal could have done is permit the claimant to amend.
Not done. Now it is a
But,
finality.
it
They
was
had a
technical.
correction.
It was technical.
No, not technical. My lord, it is.
If it permitted it to amend,
yes.
then that it is a curable defect.
Yeah, but it has not. Now we cannot
It's
go
not
into.
been cured.
Yes. The
And we are
defect
not
is-
sitting in a regular appeal. We have to be alive. We are not sitting in appeal at sorry.
at all.
Section 48 is different.
48, my lord, enforcement of an award.
Although section 34, 48 almost mirror images of each other, but on the grounds, not on the power of the court. We are not sitting in appeal. Yes.
Then this would again boil down to, but the first limb of the argument will still remain that in excess of reliefs claimed, making out a new case, traveling beyond the
Yes.
jurisdictional error.
All of those.
Jurisdictional error. So, my lord, this is so 21, my lord. The lordship would have seen the provision that
Yes.
then no, we'll show the judgments later. Then, my lord, the third limb of my argument, my lord, is that these damages which has been granted in these 29.2 million
Yes.
and 29.5 million, which is the primary damages for breach of contract only, and 110.2 million again for breach of contract. Both are breach of contract damages. Are bad because they are in excess of the liquidated damages clause in the contract itself. Where's the note?
Yes.
Now, let kindly come to the clauses.
Yes.
Kindly have convenience compilation volume 1. Yeah. Convenience compilation volume 1, where the share purchase agreement is set out. This will take some time and I come back on the next.
On the next.
Yes, because this is the last limb of my argument, and then I'll cite
Yes.
the judgments. I'll
Hardened part for further hearing on February 28, 2025. Thank you.
next week. Yes, what date? 20. Yeah, 20.
20th difficult?
No,
20. এটা একটু ওর সঙ্গে জুড়ে একটু যেটা আছে তার সঙ্গে এটা সমস্যা। I'm not calling any other matter because in 2 minutes we cannot.
Next matter also will take some time. Is that
You are there.
Marine craft setting aside award? That port trust matter.
Oh.
The Chaudhary had.
Yes.
Grateful.
May I to mention one contempt application for upgradation. Unless this contempt application is allowed, there is a very high chance or likelihood of electrical fire hazards from a transformer to the.
Contempt we only penalize people. No question of upgradation. No, sorry.
They have not taken any perceivable steps. The municipal corporation.
You could file an application for implementation, but contempt, no upgradation. Yes.
One typographical error.
One
Typographical error.
handle.
Lordship, may I be permitted?
Lordship, may I be permitted to mention a contempt petition? May it be listed, Lordship? It has not, it
Yes.
has been filed.
Lordship, Lordship, I'm praying for inclusion in the list.
What is the matter?
Lordship, your appellant land was illegally acquired by the public.
Application.
Second
Application.
appeal.
Second appeal, I'm not taking up unless it's assigned to me
It is
for admission hearing.
for inclusion in the list, Lordship.
No, sorry, refuse. Yes.
Forget to mention, my lord, serial number 40 of today's list. It's a contempt application. The reason why I'm mentioning this, my lord, I've also served notice is that the contempt during the pendency, the order has been complied with, my lord. So
You are the petitioner.
I'm for the petitioner, my lord.
So it will appear as to be mentioned tomorrow.
লর্ডশিপ
To be mentioned হিসেবে কালকে দিয়ে দেবেন 42. Yes.
লর্ডশিপ 2021 সালে আপনি সিও 592 অফ 2021 একটা জাজমেন্ট দিয়েছিলেন, ডিসমিস করেছিলেন। এই 2025 সালে এসে জানতে পারি যে অনারেবল আমার আদার সাইড যে ব্যাংক অফ ইন্ডিয়া তারা আপনাকে মিসলিড করে করে এই অর্ডারটা করেছে। তার জন্য আমি রিভিউ ফাইল করেছি।
Review. As well.
May I be permitted to mention a matter for, and it's the contempt matter.
Yes. Single sitting singly.
Both.
I was sitting singly when I passed the order. Single judge decision.
Order has not been managed.
What is the contempt is in connection with what? CO.
কেস নাম্বারটা বলো না।
Number has not been written. What can I?
হ্যান্ড ওভার দেখে নেবেন আমার সিঙ্গেল কিনা, তা নাহলে দেবেন না।
It might not be that.
Yes.
Sorry. Much obliged.
Call.
Lord, Mr. Kushal Chatterjee is appearing
Yes,
for
sir.
the Kushal Chatterjee is appearing for the petitioner. My lord, his father is seriously ill. Lord, his father is seriously ill, my lord, so he left the court.
কোন পার্টটার সঙ্গে? It is connected with.
Item number 4, 1 and 4, my lord.
the matter on the last
Yes.
My lord, arising out of same proceeding.
So I'll direct this to appear with 4 and 4 because Mr. Chatterjee is appearing. Should I adjourn that
Yes,
also? So we'll adjourn till next Friday then.
Very well.
Very well. Item 1 আর 4টা কমা দিয়ে 4 দেখিয়ে দিন বোর্ডে। And order record code CO number 3951 of 2024, comma, being connected with CO number 3718 2024, comma, both the matters be listed together. Push up since learned counsel for the petitioner is in difficulty, comma, let both the matters stand adjourned till February 28, 2025, when the two revisional applications shall be listed together for hearing as part-heard matters.
Great. Grateful. my lord.
দুটো একসঙ্গে পরে শুনবো।
Item number 12, I'm not to the minor.
Why?
Mr. Honorable Mahant is suffering from cough and cold, minor.
First motion you are paying for time. This is the first motion in the list you are paying for time. You move the matter.
I can't.
On the prayer of the petitioner, the matter is adjourned. Petitioners, the matter is adjourned for the day.
Your Lordship, in item number 3, I'm led by Mr. Rahul Pramakar. In the last occasion, Your Lordship had asked us to serve a copy. This is a applicant for expeditious disposal of the execution matter, Your Lordship.
Appeal has been preferred. What happened to the appeal?
Your Lordship had directed us. I'm led by
Yes,
Mr.
Mr.
Rahul.
Kormakar, what happened to the appeal?
Lord,
Last occasion, I
on the last occasion, there was a
You have served a
petition,
copy.
Lordship, Lord, that has been complied with. Lord, we have served.
Yes.
Lord, I am told,
Yes.
Lord, the bailiff went, my Lord, আবার আরেকটা কেন?
What about the, why two? This is for experience checkup.
Oh, this is the latest.
It has been served now.
Yes.
What is the stage of the appeal?
Lord, it's a title execution, Lord, and type.
No, there was an appeal preferred.
Yes,
In your usual fairness, you had submitted the this.
Condonation of delay has been filed. That is pending.
So no stay.
Interim order till date. Lord, I am told bailiff went there, Lord, but it was found under lock and key.
Very well. Affidavit of service filed
So
today.
this is the last order, Lord, I'm told 14th of January 2025.
Affidavit of service filed today be kept on record. Pushed up. Despite service of notice, comma, none appears for the opposite parties. Pushed up. Hence, comma, the present application is taken up for hearing ex parte. Pushed up. Learned counsel for the petitioner submits that the petitioner seeks, the decree holder stroke petitioner seeks expeditious hearing of an execution case which has been pending since 2022. Push up next para. Learned counsel submits that although an appeal has been preferred in connection against the parent decree, comma, section 5 has been allowed.
Lord, the section 5 is also pending.
An application under comma the section, an application under section 5 of the Limitation Act is still pending. Pushed up. Learned counsel also hands over a copy of an order dated January 14, 2025, passed by the executing court, from which it appears that February 24, 2025 has been fixed for a report of the bailiff. Pushed up next para. The bailiff was directed by the order to act as a liaison between the liaison, L-I-A-I-S-O-N, liaison between the decree holder with regard to the date of execution of the decree. Push up. Next para. Learned counsel for the petitioner also hands over a photocopy of the bailiff's report, which indicates that the main door of the suit property was found under lock and key. Push up. Next para. It appears that the opposite parties stroke judgment debtors are deliberately avoiding to appear before this court. Pushed up. Since the appeal preferred against the parent decree is as yet non-est in the eye of law, in the absence of any condonation of delay in filing the same, and no order is subsisting in respect of the execution case, comma, there cannot be any hindrance in the executing court proceeding expeditiously with the execution case. Push up accordingly, CO number 3304 of 2024 is disposed of by requesting the learned civil judge, senior division, second court at Alipur, to dispose of title execution case number 64 of 2022 as expeditiously as possible, comma, positively by March 31, 2025. No address to cost.
Your Lordship, for the petitioner, this
Yes,
is an
please.
application for expeditious disposal, Your Lordship. The
2022 is pretty recent.
But Your Lordship, from 2023 onwards, after I filed my written statement, they have continuously taking time. For 2024 whole year, they have taken time.
Any application is pending?
No, no application they have filed, Your Lordship. Even on the last date was 19th of November, even on that day, the plaintiff has taken time. And the court has allowed it, Your Lordship.
It's on the PH board. What is the suit for?
Suit for declaration of right title interest in respect of co-scheduled property and permanent injunction upon the defendants.
Learned counsel for the petitioner submits that the suit filed by the plaintiff stroke opposite parties against the petitioner as well as the pro forma opposite party number 4 is pending since the year 2022. Pushed up. Next para. The suit is pending on the peremptory board from August 19, 2023. That is over for about 1 year, 1.25 of a year. Pushed up. Next para. It is submitted that unnecessary adjournments are being granted in the matter on the prayer of the plaintiffs. Pushed up. Next para. The submissions of learned counsel is borne out by the certified copy of the order sheet annexed to the present application, full stop. In view of the innocuous nature of the order proposed, comma, prior service of notice on the opposite parties is dispensed with, full stop. CO number 3722 of 2024 is disposed of by requesting the learned single judge junior division at Jhargram district, Jhargram, to dispose of title suit number 31 of 2022 as expeditiously as possible, comma, positively within December 31, 2025, without granting any unnecessary adjournment to any either of the parties. No address to cost.
But I beg to appear for the decree holder opposite party. I am told, my lord, I am on caveat, but
You are told you were on caveat, means?
But they say that they have found, my lord, the endorsement no caveat.
Maybe you lost the caveat subsequently. No. You said no caveat, but caveat has been given. No, caveat note has been given. Mr. Sannal.
কপি দিয়ে পরের দিন এসো তাহলেই তো
কপি দিয়ে দিচ্ছি
You should have given a copy. If they told that they want a copy, why didn't you give it?
we are being instructed so the advocate record is
Acha. Since a copy of the revisional application is handed over to the learned advocate for the caveators opposite parties here and now, comma, in order to enable the opposite parties to prepare themselves in the matter, comma, the matter is adjourned till February 28, 2025.
28
February 28. What? You'll again go to Kumbho?
no
Yes.
I appeal for the caveator opposite.
Caveator opposite party. Yes, very good. What is the matter?
Well, I have come before your lordship challenging the impugn order dated 22nd August 2024 passed by the learned civil judge junior division second court Srirampur in title suit number.
Mr. Dotto, you are for which of the caveat, which of the opposite parties? All of them are defendants. Your caveat would be useless if I admit the appeal and if I grant interim order. Unless you are appealing for all.
No, I'm not appealing for all. I am appealing.
What is the name of your client?
SS Developer, 9.
SS Developer is 9, yes.
9 and 1. Gaur Chandra Ghosh.
So 1 and 9.
Yes.
Well, what is the matter?
Well,
what is your name?
Well, I am the petitioner. I am the
you as an advocate.
Vishwarup Chatterjee.
Vishwarup Chatterjee. Yes, Mr. Chatterjee. What is your case?
But the impugn order, which has been passed by the learned civil judge second court in title suit number 470 of 2021.
What is the suit for?
Suit for in declaration of the right title to interest in respect of the suit property, my lord.
Regarding a passage.
My lord,
your application for local investigation has been rejected.
Rejected, ma. Only on the ground, my lord, the similar kind of the petition application is pending before the Honorable High Court. That is the ground for which the learned judge, learned court below has rejected my applications, my lord. The ground, my lord, here is the
what let me see the prayer portion of the
if your lordship kindly come at the running page number 68, that is the prayer portion of my writ application.
No, first the reliefs claimed in the suit.
Yes, it is
page 28.
Yes, my lord, page 28.
And the other page is page 69.
Yes, my lord, 68.
68, sorry. Yes.
Both are different in nature, my lord. If your lordship.
Not 68, 66. Starts in my copy. What was the objection? Removing unauthorized construction. Yes, Mr. Dotto, bad order. Remanded will be decided within a week, within a fortnight.
Great.
3 rounds of litigation in the writ court. First, directed the municipality to consider.
Could the writ court grant a decree of declaration of the title?
With regard to the unauthorized construction, the court probably is
There
perturbed.
may be overlapping causes of action for different reliefs in respect of the same property. These are overlapping reliefs.
His only contention before the court below is to find out whether there is an unauthorized construction or not.
In aid of the suit, yes.
Yes.
Then I should allow the 26(9) application from here.
But
If you agree, we will do that.
But my lord, upon being directed by this High Court twice, the municipality concerned had taken local inspection and found out that there is none.
That will be an independent piece of evidence which you will be able to produce. So that you know the law. So they can always, should I allow the 26(9) from here?
My lord, if my lord is
Let me see the 26(9) schedule, the points of inspection. You allege that they have encroached. They're making construction on a private passage.
Yes, my lord.
Let us see.
the declaration is that the private passage
It's a
belongs
private
to them.
Yes, that will be decided. We cannot. And construction is also alleged in the suit that you are making construction in process. Show me the points of your local investigation, sir, Mr. Chatterjee.
Yes, my lord.
If you have not annexed the application, then I'll reject your revision.
No, no, sir. It has been annexed.
Where is that?
Page 85, my lord. The petition filed under order 26 rule 9, my lord.
Points of investigation
Yes, my lord.
should be written on the left-hand side column of your revisional application. You take a note on the left-hand side pages. Next time when you move before any court, just take a note on the left-hand column of the front page. Mr. Dotto will allow it recording your objection. Third learned counsel for the parties. Full stop. The plaintiffs in a suit for declaration and injunction are the revisionist petitioners before. Oh, we cannot do that. Other defendants are there. The plaintiffs in a suit for declaration and permanent injunction has preferred the present application under Article 227 of the Constitution of
This
India.
point, will your lordship grant stay of the entire suit? Only on this point.
Unless the suit is stayed. But difficulty is that is the difficulty.
We have reached a very advanced stage in the suit.
Everybody will suffer. Both of you will suffer.
But
Other defendants are contesting.
yes, everyone is contesting. Because
I'll grant a limited stay. Stay has to be granted, otherwise the suit will be decided without this.
Lordship can fix a time frame at least.
For
the
what?
parties are not.
If all the parties were there, I would have decided right here and now and directed the suit to be decided within a limited period. That was the
That
intention.
is this application.
Application and the suit expressing hope and trust, something like that. But we cannot do that now. And now it will go before a different bench.
Lordship can indicate that this stay will not operate stay with regard to deciding this particular application. If in the meantime.
Application has been rejected.
Oh. Now, Lordship is minded to remand it back.
No, I was minded to allow it.
Yes, by rejecting.
I cannot remand also without the other side.
Without the other.
I cannot do anything.
May I then come back with the instruction whether I
Others.
can represent others? Because the developer had been granted power of attorney by all.
You will be worst affected.
Yes.
Take instruction, Mr. Dotto, because you will be suffering more.
Yes.
That's why when I saw the name SS developer,
Yes.
I anticipated that. That's why
Building completed, sold, third party.
I'll keep it at the motion stage so that I can decide it and just direct serve copies and come back quickly.
Yes, on the others.
Others. And in the meantime, direct service of copy, but Mr. Dotto, take instruction. If you have instruction, ask your learned junior to write a letter to him that you are appealing for all so that we can take it up. The others are represented in the court below, sir.
Yes. Within a fortnight.
Within a fortnight. I'll also direct service through learned advocate in the court.
Yes.
কোন খানটা ছাড়লাম একটু বল the present revision 227 of the Constitution of India has been preferred by the plaintiffs in a suit for declaration and permanent injunction. Full stop. The declaration sought is in respect of the respect of a passage, comma, which has been claimed to be the private passage of the plaintiffs. Full stop. The plaintiffs have also sought injunction in respect of construction work being allegedly done on the said passage to block the rights of ingress and egress of the plaintiffs. Full stop. Next para. In aid of the suit, comma, the plaintiffs filed an application under Order 26, Rule 9 of the Code of Civil Procedure for holding a local investigation, comma, inter alia to ascertain the location of the property by comparing with the RS and LR Mousa maps, and as well as to ascertain whether the said passage is a part of the suit property and whether construction is being made thereon. Full stop. Next para. Prima facie, comma, valid ground for having such local investigation has been made out by the plaintiffs. Full stop. However, comma, by the impugned order, comma, the learned trial judge rejected the application outright merely on the premise that purportedly a writ petition regarding the same issue is pending before this court. Full stop. Next para. However, comma, upon a perusal of the prayers made in the writ petition, comma, it transpires that the same is with regard to alleged inaction on the part of the concerned municipality and does not touch upon the merits of the suit. Full stop. In any event, comma, the writ court would not have the jurisdiction to grant the reliefs sought in the plaint pertaining to declaration of the title of the plaintiffs. Full stop. Next para. Hence, comma, there is a strong prima facie case for hearing the revisional application on merits. Full stop. However, comma, this court is handicapped, comma, since the revisional application cannot be disposed of despite the appearance of opposite party numbers 1 and 9 through learned counsel, senior counsel now, learned counsel for the said opposite parties by caveat, comma, since the other opposite parties have not yet been served. Full stop. Next para. The petitioners are accordingly directed to serve copies of the revisional application on the absentee opposite parties, comma, directly and stroke or through their learned advocate stroke advocates appearing in the trial court, indicating that the matter shall be listed next under the same heading on March 7, 2025, when an affidavit of service to that effect shall be filed by the petitioner. Full stop. In the meantime, comma, the learned advocate on record for the caveators opposite parties is requested to take instruction as to whether the said learned advocate would be in a position to appear on behalf of the other opposite parties in the present revisional application. So this will enable serve on the through the learned advocate. Come.
For the petition, your lordship.
Yes.
Over here, between the parties, the settlement talk is going on, your lordship. So kindly adjourn the matter for 4 weeks.
What is the suit for?
Transfer of suit, your lordship, matrimonial suit.
Matrimonial suit. Learned counsel for the petitioner submits that talks of settlement are going on between the parties, full stop, keeping in view that the revisional application arises out of a matrimonial proceeding, comma, such steps on the part of the parties are welcome, full stop. Accordingly, on the prayer of the petitioner, let the matter stand adjourned till March 21, 2025, when it will be listed under the same heading. 21st March, 1 month. None appears for the parties at the time of call, full stop, as a last chance to the petitioner to appear and move the matter, comma, the same is adjourned for the day.
My lord, I am for the petition.
Yes.
My lord, there is a partition suit amongst the co-owners between the between the one ancestral house.
Right.
Where I have one agreement was executed with me, with a co-sharer of that particular house. That in that suit is going to be in finality. The Advocates Commissioner's report already filed. And it is observed that the property is not portable. In this juncture, my lord, I filed one application for Order 1 Rule 10 for addition of party in that portion, in that case, my lord, which was turned down by the learned judge, my lord.
Rightly.
Rightly, sir. But my lord, I have paid all the stamp duties, my lord.
What is your relief?
My relief is that if I am there, I will be able to purchase that very share of.
Relief available, remedy available to you if you have an agreement. You have an agreement, not
Yes,
a deed.
my lord.
Deed.
Agreement. I have
agreement to sell.
Agreement for sale.
Not a deed of sale.
No, my lord.
What is your relief in law?
My lord, I have paid all the stamp duties. Enter stamp duties is paid.
What do you do now? You have to file a specific performance suit, sir.
Sir, it is
This
a
is not a
specific
right.
performance.
You don't have any right in presentee.
My lord, I am also filed in suit. That suit is going on. They are the respondent in that particular suit.
You have made them defendants in this.
Yes, my lord.
No present right. Let us see why. What was the ground? Rightly. Sorry. The petitioners claim their rights on the strength of an agreement for sale allegedly executed by one of the co-owners of the suit property in respect of the share of the said co-owner. Next para. In a partition suit, comma, which is on the verge of culmination, comma, the petitioners. You have described yourself to be plaintiffs. Why?
No. Plaintiff in my suit, my lord.
This is against the partition suit order.
Yes, my lord.
What is your cause title?
I am applicant, my lord. My lord may come to
you should
page
have
5. Page 5.
This is not the way you draft a revisional application. You should have been the petitioner here. You should have described yourself as the proposed added party stroke petitioner versus the opposite parties would be the plaintiffs. One set opposite parties plaintiffs, the other set opposite parties defendants.
Yes, my lord.
Anyway,
have a look.
যেটা plural করেছি singular করে দিও। কি বললাম? ছেড়েছি কোথায়? Sought to have himself added as a defendant. Full stop. The said application under Order 1, Rule 10 of the Code of Civil Procedure was dismissed by the impugned order on the finding that the petitioner did not have any title in the property and was a stranger to the property. Full stop. Next para. I find that the learned trial judge was fully justified in coming to such conclusion, comma, since the petitioner does not have title in presentee in the property and at best has an actionable claim against the co-sharer who agreed with the petitioner to sell the share of such co-sharer in favor of the petitioner. First up, in fact, comma, a suit for specific performance is informed to be pending at the behest of the petitioner on such count. Full stop. Unless the petitioner's suit for specific performance is decreed and a deed is executed in favor of the petitioner, comma, the petitioner does not have any locus standi, comma, not being a necessary or a proper party, comma, to have himself added as a party to the partition suit. Full stop. Hence, comma, I find no infirmity in the impugned order. Accordingly, CO 3728 of 2024 is dismissed without any orders to cost. Next.
In this matter, I am for the petitioner.
Yes.
Vera for the opposite party.
Right. What is that?
Suit is for
only one opposite party?
I'm for the party number 1 caveat.
Why didn't you appear for the others? Your suit will be delayed.
For all, but the caveat is filed on behalf of the one only.
You have wakalatnama for the others.
No, not at this.
How soon can you file that?
Caveat is filed, but on for the.
By all.
No, for one.
How soon can you file wakalatama for the others?
I'm not for the others, but
নিতে পারবে সেটা জিজ্ঞেস করছে যে এর মধ্যে পেয়ে যাবে কি?
Plaintiffs have filed the suit together. Plaintiffs could not have filed suits separately, the same suit. So all of you are appearing to the same advocate in the trial court.
Yes.
Why has one lodged a caveat? So that can come later and recall.
At that point of signatures are not available. No, at that point of no one has appeared for the
That is why I'm asking you whether you can get wakalatama from the others.
Well, I have to talk.
Take instruction. Wait, you will miss
My suit is for declaration that certain deed has been obtained by practicing fraud, and my lord injunction and declaration that brothers have 1/4 share. My lord, that suit.
You are a stranger.
My lord?
You are a stranger to the
No.
Or you are also one of them.
My lord, during pendency of the suit, my lord, upon an application for injunction filed by the plaintiffs, my lord, an order of status quo was granted. That was till the disposal of the appeal. The suit was decreed declaring that the deed is void, deed is not binding, and every person has the 1/4 share. The plaintiffs have 1/4 share.
The deed in your favor was bad.
No, I'm
You
the
are the defendant in the
I'm
suit.
the defendant. It was against me.
That is what I'm saying.
Yes, yes.
The deed executed in your favor is void.
Yes. Therefore, a decree against me, I have preferred the appeal. In the appeal matter, I filed an application for stay of the operation of the judgment. That has been rejected without any giving any reason, non-speaking order. But I have also filed an application for renewal and prayed for ad interim order. That order has been refused.
That order is appealable. That part of the order is
That is
appealable.
title appeal. In title appeal. In title appeal, that order has been passed. Well, I have challenged both the order. The first order whereby the application for stay was refused. It is 5th of September 2024. No reasoning has been given.
No reason, but Mr. Mathur, if state.
Therefore, I have challenged both the order. This next order, my lord, 23rd of September 2024. I should not file that application for stay. I should file the application for injunction.
Yes.
Here, my lord,
But you filed a separate application.
Yes, I filed a separate application that I filed a put-up petition to take up the hearing after service. My lord, they appeared, but my lord, no interim order was granted, only adjournment. And since then, my lord, every day adjournment is going. And the lower court record has not been, my lord, transmitted.
Present defendants, the present petitioners were the defendants in a suit for declaration that a transfer deed in favor of the plaintiffs, in favor of the petitioners, was void. Full stop. The suit was decreed against the present petitioners, against which an appeal has been preferred by the petitioners. Full stop. During subsistence of the appeal, 2 applications were filed by the petitioners, respectively for stay of operation of the impugned decree of the trial court and for injunction in restraining the opposite parties from creating any disturbance in the peaceful possession of the petitioners in respect of the property, as well as a transfer, Mr. Mathur.
Yes, there is some transfer, my lord. I have mentioned in
No, you have also asked for injunction regarding transfer.
Yes, my lord, page 58. I have prayed for not to change the nature and character and from creating any third-party interest. Page 58. It starts at page 56 and the order prayer portion is at page 58.
Sorry, restraining from disturbing the peaceful possession of the restraining the respondents opposite parties from changing the nature and character of the co-scheduled property and also from creating any third-party interest over the suit property in any manner. Full stop. Next para. By the impugned orders, by the first impugned order dated September 5, 2024, the stay application was rejected without granting any reason. Full stop. Next para. However, this court is of the opinion that although the trial court erred in not assigning any reasons, I agree with the conclusion of the trial court in rejecting the stay application, since In the event stay of operation of the decree was granted, comma, the same would tantamount to allowing the appeal, title appeal, prior to hearing of the same on merits. Full stop. Hence, comma, no interference is called for, and the present revision is not entertained in respect of the first impugned order. Full stop. However, comma, by the second impugned order dated September 23, 2024, comma, the learned trial judge, comma, without assigning an iota of reason, comma, did not grant any ad interim order, which tantamounts to a deemed refusal of the ad interim prayer for injunction. Full stop. Next para. In view of the title appeal being required to be heard both on law and on facts, comma, a sufficient prima facie case has been made out by the petitioners, comma, more so since a status quo order was subsisting during the pendency of this suit. Full stop. Next para. Accordingly, the opposite parties shall remain restrained by an order of injunction.
Another thing, my lord, there is a suit between the parties for partition already pending, and there is also, my lord, restraint order. And also this order is, if you also kindly come to the impugned order, that portion,
Yes.
I for LCR. LCR is not present. That portion.
LCR is not immaterial.
But on that
How,
one
what
was-
will the LCR do? Restraining the opposite parties from changing the nature and character of the co-scheduled property in the suit, co-scheduled property of the plaintiff, as well as from creating any third-party interest over the suit property till disposal of the present revisional application. Full stop. Next para. In view of appearance through learned advocate by lodging a caveat, comma, service of copy of the revisional application on the opposite party number 1 is dispensed with. Full stop. However, comma, the petitioner shall serve copies of the revisional application on opposite party numbers 2 to 5, indicating that the matter shall be listed before the appropriate learned single judge having determination, subject to being mentioned for inclusion in the list by the parties. Full stop. An affidavit of service to that effect shall be filed on the next returnable date.
My lord, subject to correction, my lord, the product 13 rule 1 and 2 is still pending, my lord. My lord,
Yes,
that
that is why I asked you at the outset. If you said that you would file Vakalatna for all the plaintiffs, I'll keep it next week and I'd have disposed it of. But since you choose not to do so, for it.
I'm grateful.
All the plaintiffs, all the plaintiffs filed a suit. All the plaintiffs are the only opposite parties. You have chosen to lodge caveat for one. So the other plaintiffs must suffer. You also suffer. I don't understand the fun of lodging a caveat for one of the plaintiffs. Doesn't mean anything.
At that point of, my lord, one person is available that time, my lord.
Anyway, next.
Lordship.
Yes, Mr. Dotto, what is the matter?
For expeditious disposal of my application for appointment of a commissioner for examination of the petitioner defendant, number 1, Debenese, and recording his evidence. my lord.
Since when is it pending?
It's pending since March 2024. 80-year-old defendant, my lord, suffering from various.
In view of the nature of the order proposed to be passed, no prior service of notice is being directed. Full stop. The defendant number 1 is aggrieved by long pendency for over a year, for about a year, of an application for taking evidence of the petitioner, yourself.
Yes, defendant.
Evidence of the petitioner, comma, who is the defendant number 1 in the suit, comma,
Debenese, my lord.
Debenese, on the ground of the advanced years of the petitioner, comma, who is an octogenarian. Full stop. Next para.
Suffering from ailments various.
It also transpires that the petitioner is suffering from various ailments. Full stop. Accordingly, comma, sufficient urgency has been made out for expeditious disposal of the said application. Full stop. Hence, CO number 3730 of 2024 is disposed of by requesting the learned 10th bench, City Civil Court at Calcutta, to dispose of the pending application of the defendant number 1 stroke petitioner under Order 18, Rule 16, read with Section 151 of the
And
Code of Civil
75
Procedure.
ought to have been 75 because the 75, my lord, appointment of commissioner comes. Though that's not it quoted, my lord will kindly.
Anyway, what that is the application. Application under such and such pending before the said court in connection with title suit number 1638 of 2021 as expeditiously as possible, comma, positively within 1 month from the date of communication of this order to the learned trial judge.
And one more innocuous prayer, my lord, which my lord, I think my lord defendant will not
Yes.
be prejudiced, my lord, hearing of the suit be expedited. I am the defendant, I am seeking a suit.
What is the year of the suit?
It's a suit of 2021. And I am an 80-year-old
It
man.
is expected that keeping in view the age of the petitioner, comma, the learned trial judge shall, comma, after deciding the application and disposing of all pending applications, comma, in any, if any, comma, endeavor to dispose of the suit as expeditious as possible, comma, preferably within a period of 1 year from the disposal of the pending applications.
Thank you.
Item number 13. Item number 13, I am appearing for the petitioner.
Yes, please.
Lordship, here, Lordship, the application for handwriting expert
Right.
has been refused by the learned.
You are the defendant in the court.
I'm the defendant.
What
in
is the
court
suit for?
below. Suit is the partition suit, Lordship. Lordship, the
Have you got any counterclaim?
Lordship, no. I have filed the written statement in time, Lordship, but what happened, Lordship, the AD card, which has been signed, that is signed as Amit Kumar Ghosh, that is not in my style.
AD card for what?
That for the summons which has been sent to
You have
my
appeared in the
address.
suit. What is the necessity of
Lordship, the
handwriting?
thing is that my signature is Amit Ghosh, but the
Suppose your signature in the AD card is wrong. You have now appeared in the suit. What is the use of this futile exercise?
what happened, Lordship, this Amit Ghosh and Amit Kumar Ghosh, they are representing me as Amit Kumar Ghosh, but I am Amit Ghosh. This is the thing, and the forgery is going on from starting from the signature and in all the applications also. Where is
Your signature in the AD card of the summons.
Lordship?
How will that make a difference? You prove your identity that you are Amit Ghosh, not Amit Kumar Ghosh.
But the shoot is going as Amit Kumar Ghosh. This has been also prayed before the court below that let it be recorded as a Amit Ghosh.
Your signature on the AD card of the summons does not make a difference whether you are Amit Kumar Ghosh or Amit Ghosh.
But the Lordship,
Because summons, that only deals with the summons.
Lordship.
Now, summons, that is a closed chapter because you have appeared in the suit.
Lordship.
So you prove your evidence, prove your identity otherwise in the suit. This is not necessary.
Lordship, what happened, Lordship?
No.
In the shoot also, this going in the name of Amit Kumar Ghosh. I have applied, I have filed the application that it will be Amit Ghosh, not as Amit Kumar Ghosh.
That will be decided independently.
My signature is also Amit Ghosh.
In the AD card, your signature is Amit Ghosh.
Amit Kumar Ghosh. That has been forged.
So therefore, at best, you can say that you did not receive the summons. Somebody else signed for you.
Lordship.
Even if that be so, you have now appeared in the suit.
Lordship.
What
but
is the fun of having that examination?
Lordship, my application, wherever I am application is being made, wherever I am signing, it's signing as Amit Ghosh.
Precisely that has been held by the trial court. As per this court, since both the defendants has come on record should be, and are contesting the suit, so AD card or signature thereupon becomes redundant. Absolutely.
But Lordship, what happened, Lordship, if the shoot is going on in the name of Amit Kumar Ghosh and I am Amit Ghosh.
Prove your identity as Amit Ghosh by independent evidence, ma'am. You adduce evidence, bring witnesses, bring your documents, bring your birth certificate, your prenatal certificate, your school certificate.
Liberty be given, Lordship, on that.
No liberty is required. We won't add anything to what right you already have. You have your right, you advise your client. The present revisional application has been filed challenging the refusal of an application for appointment of a handwriting expert made by the defendant stroke petitioner in a suit for partition, comma, in order to ascertain the veracity of the purported signature of the petitioner on the acknowledgement due card pertaining to the summons served on the petitioner. Whose of next para, learned counsel for the petitioner argues that although the petitioner is actually Amit Ghosh, comma, the plaintiffs in the suit have been proceeding on the plaintiff in the suit has been proceeding on the mistaken presumption that the petitioner is one Amit Kumar Ghosh, full stop. As such, comma, to establish the identity of the petitioner, comma, such appointment of handwriting expert is necessary. Full stop. Next para. I find from the impugned order that the learned trial judge arrived at the conclusion that in view of appearance of the defendants who are already contesting the suit, comma, the acknowledgement due card relating to the summons or the signature thereupon become redundant for consideration and the application is dilatory. Full stop. Next para. I do not find any quarrel with such proposition and is am ad idem with the view of the learned trial judge, comma, since after the appearance of the petitioner stroke defendant in the suit and upon contesting the suit, comma, the question of veracity of the signature on the ID card pertaining to the summons becomes irrelevant. Full stop. Next para. In any event, comma, the identity of the petitioner or the proof thereof does not hinge upon the purported signature of the petitioner on the acknowledgement due card accompanying the summons. Full stop. The petitioner in any event, I'll put that in, is at liberty to prove his identity by way of independent evidence, comma, either documentary or oral, comma, in the suit. Full stop. Next para. Accordingly, comma, no case has been decided against the petitioner by the impugned order and no interference is called for. Full stop. CO number 3731 of 2024 is accordingly dismissed without any order as to cost in the light of the observations made above. No, dismissed, squarely dismissed, but in the light of the observations made above, which may help you. Next. Yes.
Plaintiff, a suit for eviction under the Transfer Property Act.
Yes.
The petitioner, my lord, is looking caveat.
Yes, only that. Now it's the job of the court also.
No, no, no.
No, no, not for you. Every matter.
It's our duty, my lord. But
I could have asked you. Instead of that, you start hearing and anyway. So, plaintiff in a suit for?
Suit for eviction under the Transfer Property Act, my lord.
You are the plaintiff.
I am the plaintiff.
Yes.
An application was filed under Order 39 Rule 10 for deposit of the admitted amount as a rent in the court below. That was filed.
Order?
Order 39 Rule 10.
What is that? Forgotten. I'll just check up. I have a SIPS.
No. What is the way? For deposit of money.
Yeah, money, etc. Whether the subject matter of suit is money or some other thing capable of delivery, you have to admit that he holds such. Yes, you. What is the application of this?
Yes, because my case is the admitted he's in his written statement admitted that this is the amount of rent.
You filed for suit for eviction
under the Transfer Property Act.
Yes, 106 or
106.
Very well. Give a notice and
I filed an application for deposit directly because 2018 onwards he did not depositing the amount, which is the admitted. Well, now, my lord, it is held that in irrespective of fact whether it is a suit for before the degree is passed, the tenant, a person occupying a portion, is liable to pay the admitted amount, which is month by month, because there is no scope for default and other things.
Where is the admitted amount? Yes.
Yes, in a written statement, he admitted that this is the amount. The in the plaint also
shows that. Yes. No, in the written statement, it has to be an admission.
No,
the written statement you have there. You asked for.
This application was filed.
You asked for arrear rent also.
Yes, the admitted amount, which they have admitted.
No, in your suit there is a prayer for that.
Suit for eviction. This is eviction.
Then?
In such a suit, why not?
Achha, where is the admission in the written statement?
55. If you lordship, I turn to page 70. Yes. Beg to be corrected, my lord. Can you turn to page 68, my lord? I beg to be corrected.
138. 71, page 71.
Therefore, sir, arrangement continuing the 3 years, 4 years after the say monthly rate was revised.
Page?
Page 68, my lord. Paragraph 10. I beg to be corrected, my lord.
Paragraph 10, yes.
7,500.
Is paying?
Yes. No. Our case is since 2018, he was not paying the same. Be as it may, I filed a suit for eviction and for arrear rent.
No, you have not filed for arrear rent.
If you lordship, can turn to the plaint.
You said only for eviction?
So sorry. Arrear rent. Also, my lord, can turn to my plaint. That is at page 55.
55 is a plaint.
Page 55, you lordship, suit for eviction and for recovery of arrear rents. Page 55, annexary.
Arrear rent of 10 lakh?
Yes.
Very well.
This application was filed. This 24. in the month of January 2024.
Acha, very well. What is the admitted amount? Show us his written statement. Show
But
me.
no, my lord, don't need to. My application is kept pending, keeping without fixing any date. The defendant filed a suit for declaration of territory in the Panchayat area.
Declaration of
Tenancy right is also Panchayat area, claiming to be the tenant under the Transfer for a Premises Tenancy Act, and that suit is going on without fixing my application for duration.
fix a hearing date of.
Yes,
What the fix
without fixing it, no date has been fixed.
What is your prayer? That application be heard out?
Yes, man. Apart from that, my lord, I cannot say.
I'll hold that it is no, though it is not maintainable, but it will be heard out within it. You know, of course, observation, and with that, I'll send it out. I'll direct it to be decided within a week from. Where is the application? Let us see.
Yes, application.
Novel innovations, Mr. Rai.
No, there is a judge. Now, my lord,
There's a judgment also, novel judgment.
Apex Court.
Where is that petition? I'm
Yes.
very interested in that. Let me see.
192. If you admitted something, my lord, there is no problem.
Supreme Court also you appeared in that. No.
Okay, no, my lord, I am a small advocate. Not-
Small advocate having large knowledge.
No. No,
Anyway, when was it filed?
it was filed, my lord, on 25th January 2024.
26 January 24.
25th January.
So it's still pending.
No date has been fixed. And lastly, my lord, in the month of the suit was fixed in the month of
Other applications are also pending.
Order 6 it is their application
That is also pending.
that is pending.
Very well.
It was fixed. 9 January was date. Next June, in the month of June, it has.
In view of the innocuous nature of the prayer, no prior service of notice of the appeal of the revision on the other side is on the opposite party is directed. First of next para, the petitioner, comma, in a suit for eviction of the opposite party under the provisions of the Transfer of Property Act 1882, comma, took out an application under Order 38, Rule 10.
Order 30. Order 39, Rule
39, Rule 10 of the Order 39, Rule 10, read with Section 151 of the Code of Civil Procedure, which has been kept pending by the learned trial judge since January 25, 2024, without even fixing a date for hearing of the same. Full stop. In view of the above circumstances, comma, CO number 3732 of 2024 is disposed of with directing the learned trial judge to learned trial judge na kore, learned civil judge, senior division, 3rd court at Howrah, district Howrah, to fix a date for hearing of the pending application under Order 39, Rule 10 of the Code of Civil Procedure, filed at the behest of the petitioner as expeditiously as possible, and to dispose of the same within a month from the date of communication of this order to the court below. Full stop. It is made clear that it will be open to the learned trial judge to dispose of the other pending applications in connection with the suit bearing title suit number 171 of 2019, comma, as well, and to take up the suit for hearing as expeditiously as possible. No less to cause urgency. Next.
I supply the judgment. to your lordship.
Yes, Mr. Rai. Supply really. I mean, I'm interested academically. What does it say that?
That you have to deposit the admitted amount during pendency of the suit.
No, under Order 39, Rule 4. Order 39,
Rule 10.
Rule 10 is the interesting portion.
That portion has also been recorded, but to some extent it has gone to that. If you admit, if you are in occupational portion of the property, and you have admitted that you.
Yes, why not? In fact, Order 39, Rule 10, I mean, affords that opportunity. You are right.
So that is why one of said.
I've never looked into this provision in my life. So for the first time.
I'll supply the judge.
Yes, next.
My lord, 15, I seek leave to move virtually, my lord.
Absolutely, granted. You are for the petitioner.
I am for the petitioner, my lord. My lord, this is for expeditious disposal, my lord. It's a suit for eviction and recovery of khas possession.
What is the stage? What is the stage?
My lord, stage is hearing of 7-3 application, and it has been at this stage since 19th of December 23. And my lord, since it is a 2013 suit, my lord may also be pleased to expedite the suit itself, my lord.
Very well, very well. In view of the nature of the order proposed to be passed, no prior service of notice is directed on the opposite party. The plaintiff stroke petitioner filed a suit for eviction of the opposite party in the year 2013, which is still pending. Pushed up an application filed under section 7 within bracket 3 of the West Bengal Premises Tenancy Act 1997, filed by the plaintiff stroke petitioner, has also been kept pending since December 19, 2023. Pushed up next para. Being satisfied that now this court being satisfied, now I am satisfied that the the pending application is of a brief conspectus and ought to have been disposed of by now. Full stop next para. Accordingly, CO 3733 of 2024 is disposed of with a request to the learned civil judge, Junior Division, 7th Court at Howrah, District Howrah, to dispose of the pending application of the petitioner under section 7 within bracket 3 of the 1997 Act in connection with title suit number 11 of 2013 as expeditiously as possible, comma, positively within 1 month from the date of communication of this order to the said court. Full stop. It is expected that the learned trial judge shall, comma, thereafter, comma, dispose of the suit as well, comma, subject to the outcome of the application under section 7 within bracket 3, comma, preferably within 6 months thereafter. Full stop. No rest to cause. Urgency.
I'm grateful, my lord.
Thank
you.
Item number 16.
16, my lord, I am Bekri, account the petitioner plaintiff, my lord.
Yes.
I have instructions to appear, though there was no caveat.
Give a copy. For all the opposite parties, Mr. Shaman?
Defendant original, there were by virtue of this impugned order and two
Added.
persons have been added as a defendant. I'm not representing them. I'm the original defendant.
No, on whose prayer? They themselves sought for addition.
No, they themselves.
Then you have to serve them also. What is the? Then I'll hear you.
Yes, my lord. This is my property, my lord. I entered into an
Mr. Shamul, if I dismiss it, then I'll request him to give a copy, and if I don't dismiss it in any event, they'll give a copy. Yes.
I'm the owner of the property in question, my lord. I entered into an agreement for development in respect of the said property, my lord. As per the development agreement, I was entitled to 40% of the built-up area as well as 5 lakh rupees. Now, they have carried out the construction to some extent, and they have given me some portion, but not the entirety of the 40%. In addition,
means the original defendant.
Yes, the original defendant. Furthermore, the original defendant also carried out some unauthorized construction, illegal constructions.
Yes.
I cautioned him. In spite of that, the unauthorized and illegal construction was carried out. Suit is for declaration of my 40% right as well as for injunction. Thereafter, my lord, I filed this suit and prayed for injunction. Injunction order was granted in the form of status quo. That was made absolute. The interim order was passed on 14/1/2005 and the interim order was passed on 31/8/2005 and it is continuing. 31/8/2005.
2004 must be.
2005. 14/1/2005 and 31/8/2005. Initial order was on 14/1/2005.
Oh, 2005. I'm sorry, I'm 2020. Oh, 2005?
Yes, my lord.
Yes, then?
And the further order was on 31/8/2005. In spite of such order, my lord, transfer took place. Sale deeds were executed.
It was a status code.
I have a status order in respect of the
you want to add those?
No, they made an application for addition of party, and I filed an application under section 94, complaining before the court below the illegalities carried out by the original defendant number 1. My application under section 94 has been rejected, and although the other added
section 94 of the civil procedure. For what?
For my lord, for resisting direction and for issuance of warrant of arrest against the opposite party number 1.
But what have you challenged now?
Section 94 has been rejected. I am challenging that. An application for addition of party has been allowed. I am challenging that also.
Why shouldn't they be added? It's an irregular sale at best, but the sale is not a nullity.
Even then, there are two parts of the order. One is section 94, other is the order 1 rule 10. Even if I go, if I cannot challenge the part by which they have been added, I can challenge the part by which 94 has been allowed.
94 has been refused.
Refused.
The present revisional application has been filed by the plaintiff in a suit for declaration of his 40% share as a developer of the suit property, as well as consequential reliefs, including the relief of injunction, permanent injunction, which of next para in the suit, comma, an order of status quo, an ad interim order of status quo was passed on January 14, 2005, which was made absolute on August 31, 2005. Full stop. According to the petitioner, comma, in the teeth of the said restraint order, comma, the original defendant in the suit transferred portions of the property in respect of the added defendants stroke opposite party numbers 2 to 6. Full stop. Next para. The on the application made by the original defendant under Order 1 Rule 10, comma, the
Order 1 Rule 10 was not filed by the original defendant.
By the others.
on
by
the
others.
application made by
For
the
subsequent purchase.
alleged subsequent purchasers, comma, under Order 1 Rule 10 of the Code of Civil Procedure, comma, the same was allowed, and the subsequent purchasers being opposite party numbers 2 to 6 were added as parties to the suit. Full stop. Next para. By the same order, comma, an application filed by the present petitioner under Section 94 of the Code of Civil Procedure seeking inter alia issuance of warrant of arrest and other remedies to prevent the ends of justice from being defeated in view of the sale having been allegedly carried out in the teeth of the status quo order, comma, was dismissed by the learned trial judge. Full stop. Being aggrieved with both components of the order, comma, the present revision has been preferred. Full stop. Since the prima facie case has been made out by the petitioner for hearing of the revisional application on merits as to whether, in view of the alleged violation of the injunction order, comma, the petitioner was entitled to remedy under Section 94 of the Code of Civil Procedure, as well as whether the sale in favor of the added defendants was a regular and valid sale, comma, the petitioner shall serve copies of the revisional application on the opposite party on the opposite parties. Full stop. Next para. Since Mr. Supratik Shamul, comma, learned advocate, has instruction to appear on behalf of the defendant stroke opposite party number 1, comma, the service on the said opposite party shall be effected through Mr. Shamul and by registered post with registered speed post with acknowledgement due on the other opposite parties. Full stop. Next para. An affidavit of service to that effect shall be filed on the returnable date. Full stop. The matter be listed for hearing before the regular bench, having determination subject to being mentioned and mentioned by the parties and being included by the said bench. Full stop. Next para. What interim order do you want?
Lord, I have
There is
though prayed for
stay of suit.
stay of suit, stay of operation of the order by which, my lord,
Stay
they
of
have been
operation?
added. They have been added as a party.
But then I have to stay the suit also.
I leave it to your lordship.
Stay of suit would suffice then. You have not prayed for stay of suit.
I have not prayed for stay of suit. I have prayed for only, my lord, the stay of operation of the order by which they have been
What
added.
means the revision is allowed before. So I'm not passing any interim order. Take a chance. Thanks.
Night, Raman, now.
Number 17.
17, my lord, I am for the petitioner.
February 25.
এটা আপলোড হয়ে গেছে?
না, না,
দুটোই হবে তুমি। ও এটা হ্যাঁ হ্যাঁ রাইট। Sorry. Yeah. 17.
And I'm for the petitioner defendant.
Right.
My lord, over my property, the plaintiff petition opposite party has encroached upon and carried out the construction for illegal gumti.
Illegal?
Illegal gumti. And thereafter filed a suit for declaration and for injunction. I entered appearance in the said suit and he's contesting the suit and I filed a counterclaim for his removal lordship. In the said suit, I filed an application for appointment of a learned commissioner for carried out inspection and to file a report. That order was allowed. The learned commissioner was appointed. Learned commissioner files a report. That report was accepted. Challenging that, my lord, the civil division was preferred before this honorable court.
Yes.
The civil division was rejected by this honorable court. Against that, they preferred a special petition before the honorable Supreme Court. Even the special petition was rejected. Now that since it has been rejected by all the forums and the report filed by the commission has been accepted, now they filed an application for amendment. They've been trying to change the nature and character of the suit. They have been trying to infringe upon the report filed by the learned commissioner.
How? Let us see the amendment.
Lordship kindly sees the order passed by our honorable court at page 64. This is the ordering portion. The report of the nature submitted by the commissioner is not to be
So the
like
challenge, the revisional application was preferred against the acceptance of the report.
Yes.
Not against the appointment of commissioner. That's correct. Yes.
Now, Lordship, the report was ultimately accepted
Yes,
because
yes.
it was challenged up to the Honorable Supreme Court.
Yes.
Now they have filed, my lord, an amendment application whereby they have tried to question the my schedule as well as the report filed by the commissioner, which has been allowed by the learned court below with a by way of a very cryptic order without assigning any kind of reason at all.
Show me the schedule of the amendment, Mr. Bade.
Yes, Lordship kindly comes to page 52.
52.
Yes, typed copy.
Right. Yes.
প্রকাশ থাক আবশ্যক যে বিজয় দাস কর্তৃক বিবাদী পঞ্চমগণ বরাবর গত 1/9/2005 তারিখে সম্পাদিত কোবালা দলের রিসাইটাল হইতে বাদীগণ সর্বপ্রথমে জানিতে পারে যে বিজয়কৃষ্ণ দাসের প্রাপ্তীয় সম্পত্তি পূর্বে তাহার পিতার রামশরণ দাস কর্মকার সেক্রেটারি অফ স্টেট ফ্রন্টের ডিকাট হইতে গত 11/8/1915 তারিখের ইন্ডেঞ্চার দলিল মূলে জেলা থানা বাঁকুড়ার অন্তর্গত 8 কাঠা বাস্তু সম্পত্তি প্রাপ্ত হইয়া সত্যবান মতে দখলকার হন। পরে রামশরণ দাস কর্মকার রামনারায়ণ দাস কর্মকারের পত্নী বরাবর এক চুক্তিপত্র দলিল করিয়া দেয়।
Yes, yes. The defendant in a suit for declaration and permanent injunction has filed the present revisional application, footstep, by the impugned order, comma, an application for amendment of plaint filed by the plaintiff opposite party has been allowed, plaintiff's opposite parties has been allowed by a cryptic order without assigning appropriate reasons. Footstep. Next para. The brief facts of the case are that initially in the said suit, comma, the defendant stroke petitioner had filed an application under Order 26 Rule 9 for appointment of a survey past commissioner for holding local investigation, which was held and a report submitted in respect of encroachment of the suit property, comma, which the defendant claims to be his. Footstep. Next para. The acceptance of the commissioner's report was challenged in a revisional application, which was dismissed. Footstep. The said order was affirmed further up to the Supreme Court by rejecting a special writ petition filed by the plaintiffs. Footstep. Next para. However, comma, by way of the amendment now sought, comma, the plaintiffs inter alia seek to invalidate the commissioner's report, which has been accepted up to the Supreme Court. Footstep. It transpires from a bare perusal of the amendment sought as reflected in the schedule of the amendment application that the plaintiff has, comma, plaintiffs have, comma, among other things, comma, have sought a declaration, has sought to allege that the commissioner's report is erroneous and incomplete and should be declared invalid. Footstep. Next para. Such prima facie, comma, such amendment intends to achieve indirectly what the plaintiff's opposite parties could not do directly by seeking to invalidate a commissioner's report which has been accepted and affirmed up to the Supreme Court. Footstep. Hence, comma, the revisional application is required to be on such ground, to be heard on such ground, as well as on the ground as to whether the impugned order should be set aside on the ground of being cryptic insofar as it is devoid of reasons worth the name. Footstep. Accordingly, the petitioners shall serve copies of the revisional application all the opposite parties.
No, there are
only one. Member chairman is not.
If a lawsuit direct, I will serve upon all of them.
Yes, yes. shall serve copies of the revisional application on all on the opposite parties, indicating that the matter shall be listed for hearing before the appropriate learned single judge having determination, subject to being mentioned for inclusion before the said bench by the parties. First of next para, the petitioners shall file an affidavit of service to that effect on the returnable date. Stop. There shall be stay of operation of the impugned order as well as stay of all further proceedings of the suit till disposal of the revision letter.
I'm grateful to your lordship.
Item number 18.
Yeah.
I appear on behalf of the petitioner. Mr. Rai is leading me.
Which Mr. Rai?
Narayan Rai. Can this be taken up any day next week, sir?
What is the matter about? He has not come to court.
He is engaged in courtroom now.
What is the matter? If
This is a suit
if I'm
for the-
inclined to dismiss it, then I'll adjourn it. Otherwise, I'll record his name and
And
yes.
this is a suit for declaration and injunction, my lord, wherein we have filed an application under Order 7, Rule 11 that has been rejected, and we have come up before this your honorable court. We
711 on the ground of
on the ground that in respect of Section 16 of the Indian Electricity Act and the Telegraph Act, the compensation which he has sought for drawing up the pipeline cannot be sought for in this plaint because they, according to Section 16 of the Indian Telegraph Act, it should go before the learned district judge. Manavi, kindly come to page 44, that is the Order 7 Rule 11 application.
No, first show me the prayer in the plaint.
Plaint, that is at page 27. Twofold prayers, my lord. First is for declaration and second is in respect.
First relief cannot be granted.
I know.
Bring Mr. Rai. On the prayer of the petitioner, the matter is adjourned for the day. No partial rejection of plaint.
I have got hold of a judgment of the 2018.
Partial rejection.
But Order 16, there is something which I wanted to find out after that also.
If it can be segregated.
Yes.
But the reliefs can be segregated. Request hearing, let Mr. Rai come.
It is
Don't
required.
take the risk. I may dismiss it. Yes.
I'm grateful, man.
Don't give the name of Mr. Rai. Only your name. Yes.
Petitioner before my lord is a sole defendant in a suit for eviction and recovery of house possession on the ground of trespass. Earlier, the opposite parties being the plaintiffs filed another suit. And at the time of framing of issue, it was detected that the suit was filed in a wrong forum. And the learned trial judge dismissed the suit. Challenging that order, the plaintiffs therein preferred one revisional application and it was heard by my lord. Kindly have a look at page 18.
Just tell me what happened. What is the then I'll
My lord,
so revisional
please
application was
allowed and plaint was returned. And there was a liberty given to the defendant that if the plaintiffs take any advantage of the interlocutory applications, then the
no, 1 minute. They filed that suit. It was held by the learned trial judge that it was not maintainable before that court.
Yes.
I set it aside and said it was maintainable before that court.
Return the plaint in a proper forum. Instead of rejecting the suit, the learned
instead
trial
of
judge
rejecting, return it to present. Now what has happened?
returned. Suit has been returned. Now, liberty was given to the defendant that if the plaintiffs want to take any advantage of the interlocutory orders,
yes,
the defendant may have the liberty to file appropriate application and that application should be heard and decided by the transferring bench.
Application for what?
Any application. Now, what happened in the earlier court, learned commissioner was appointed to take inspection of the suit property and filed a report, but that report was not exhibited or that stage was not done. Now, in this suit, at the time of peremptory hearing, the plaintiffs tendered the certified copy of the commissioner's report and that has been exhibited, marked. At that point of time, the defendant raised objection and it was marked as with objection. And on the very subsequent date, the defendant take out an application stating that since that commissioner's report was not exhibited in the earlier suit and by the order by which the commissioner was appointed, the learned trial court didn't have the jurisdiction to pass the appointment because that was wrong forum. So for cancellation of that document, that document should not be marked as exhibit. And with that application, another application was taken out by the defendant, praying for amendment of pleadings. Both the applications, Order 6 Rule 17, both the applications was rejected.
Why the amendment application is rejected? What was the amendment sought?
Amendment sought for certain incorporation of certain facts which could not be incorporated, and because the WS was filed during COVID situation. That was rejected. Both the applications was heard analogously and rejected by a single order. My lord, kindly have a look at page 18 first.
Yes, 18.
Here, page number 2, running page 19, second paragraph. The liberty was there.
But you are not challenging any interlocutory order passed by the previous court. Appointment of commissioner, you are not challenging.
Appointment of commissioner not challenging, but the
why? How does this order help you?
My lord, this order, on the basis of this order, the defendant filed an application stating that since the learned commissioner filed the report there, but the order itself by which the commissioner was appointed there, the court passed the order without having jurisdiction. So that commissioner's report should not be taken into consideration.
And what is
that's my lord, kindly have a look at my application.
Yes.
It is annexed. It is at page, this application with which this order, it starts from page 14. This application was taken out by the defendant under section 151.
But I held that the court did not have jurisdiction.
Yes, did not have jurisdiction because city civil court due to police station. Now, kindly have a look at page 2, paragraph 15 of the application under section 151. Learned commissioner inspected the place, filed the report. After that, suit was dismissed. Returned.
How was it dealt with by the learned trial judge in the impugned order? Let us see.
Yes. Kindly have a look at the impugned order. This is the first part. Page 3, internal page 3 of the impugned order. Last portion. Furthermore. It just says it should be heard at the time of trial, passing of judgment. At the very date, on the very date when that document was tendered and marked, I raised the defendant raised objection. The petitioner before my lord raised objection, and subsequent date this application was taken out because they are neither the
both applications are rejected.
Both the applications rejected against that.
The present challenge has been preferred by the defendant in a suit for declaration of title, comma, for declaration, comma, recovery of first person and consequential reliefs. Full stop. The brief facts of the case are that initially the suit was presented in a court lacking territorial jurisdiction. Full stop. The matter came up to this court where the revisional court had observed that the impugned order was to be set aside, comma, directing the learned trial judge to return the plaint for being presented before an appropriate court having jurisdiction, comma, thereby upholding that the erstwhile court did not have jurisdiction to take up the matter. Push up. An observation was also recorded in the said order of this court to the effect that in the event the court which passed the interlocutory orders did not have jurisdiction, comma, it would be open to the opposite party within bracket present petitioner bracket closed to take out appropriate application before the transferee court and stroke or the court where the matter will now be heard, comma, taking such objection. If taken, comma, the said court would be free to decide the same on merits upon hearing both the parties. Next para. Thereafter, the suit was the plaint was returned and presented before the current court where it is pending. In the said suit, comma, the plaintiff sought to have exhibited the certified copy of a commissioner's report which was submitted before the earlier court which did not have territorial jurisdiction pursuant to an order appointing commissioner. The objection taken by the present petitioner was that the previous court, comma, not having territorial jurisdiction, comma, was incompetent to appoint a commissioner, and as such, comma, the commissioner's report, comma, which was never exhibited in before the earlier court, comma, could not be marked as an exhibit in the present suit. Full stop. Next para. Despite such objection, comma, the commissioner's report was marked. Full stop. The petitioner thus filed an application under section 151 of the Code of Civil Procedure seeking, what is the exact prayer made by you? That the
Kindly have a look, page 16. Disallow the plaintiffs under PW1 to tender the certified copy of the disallow.
Seeking an order disallowing the plaintiffs and or PW1 to tender the certified copy of the commissioner's report. Full stop. Next para. A further application was filed for amendment of the written statement by the present petitioner, comma, thereby seeking to incorporate certain facts which, according to the petitioner, comma, could not be incorporated during the pandemic situation. Full stop. Next para. The learned trial judge rejected both the applications. While rejecting the first of the applications, comma, it was held by the learned trial judge that the defendant had already raised objection in respect of the commissioner's report at the time of marking as exhibit, and so the matter should be considered by the court at the time of arguments and passing of judgment. This I don't find any discrepancy. I mean, he's right. Because your application was for not allowing it to be tendered. It has been tendered and it has become
because
evidentiary value will be, I'll observe that the evidentiary value will be considered. Court has also said so.
My lord, but
regarding the order 6 rule 17, I will interfere, but not this.
Well, I am leaving it to my lord.
So next para, however, comma, I do not find much irregularity in such observation, comma, since in any event, comma, in view of the objection taken by the petitioner, comma, the evidentiary value of the commissioner's report as an exhibit shall be kept open for being considered by the learned trial judge at the time of final hearing of the suit. Full stop. Next para, hence, comma, no interference would be called for on that count, and hence the revisional application need not be entertained on the said aspect of the matter. Full stop. Next para, however, comma, with regard to the rejection of the amendment application, comma, I find that the learned trial judge was cryptic in its cryptic in the dismissal, inasmuch as it was merely recorded that trial has already commenced, and if the petitioner sought intended to amend file an amended written statement, she could have filed it before the commencement of trial, comma, thereby overlooking the proviso to order 6 rule 17 of the Code of Civil Procedure. Full stop. Next para. Accordingly, the revisional application shall be heard on the limited question as to whether the learned trial judge was justified in rejecting the amendment application of the petitioner without considering the explanation for the delay in filing the same. Push up. The petitioner shall serve copies
There are
of
8.
copies of the of CO number 3738 of 2024 on the opposite parties, indicating that the matter shall be listed before the appropriate learned single judge having determination subject to being mentioned by the parties for inclusion before the said bench. Full stop. The petitioner shall file an affidavit of service in that regard on the returnable date. Full stop. Next para, there shall be stay of all further proceedings in title suit number 1642 of 2019 pending before the 13th bench City Civil Court at Calcutta till March 31, 2025 or until further order, whichever is earlier. Preemption under section 8? Yes. Preemption on what ground? Co-sharer or? Only co-sharer. Yes. What happened?
Lord, the petitioners approached before this honorable court, appending the order by which the learned court below granted the defendant number 1 to submit its written statements after a lapse of 13 years.
13 years.
13 years. Ground is in the application that the learned advocates of the defendant has failed to take steps. 2010, the suit was filed. 2011, November, the matter was gone to the plenary court for expert hearing.
You have challenged that only.
That was, I'm challenged that. And one more thing, and that too, the application was filed for contesting the suit by the defendant number 1, who has subsequently, who has transferred the property to the defendant number 11 and 12, and the relief which I sought for against the 11 and 12, defendant number 11 and 12. Well, he has no scope, only to delay the proceedings, nothing else. Only to delay the proceedings.
The preemptors in a proceeding under Section 8 of the West Bengal Land Reforms Act 1955 is the petitioner, the preemptors in an application under jeta bollam 55 are the petitioners before this court. Full stop. By the impugned order, comma, the learned trial judge has permitted the defendant number 1 stroke opposite party number 1 to file his written statement after 13 years from the institution of the preemption case. Full stop. Next para. It is submitted by learned counsel for the petitioners that the relief sought in the preemption case is primarily against the other defendants, and as such, comma,
11 and 12. Note, can you mention?
Relief sought is primarily against opposite party numbers 11 and 12, and as such, comma, it is doubtful whether the opposite party had any locus standi or justification for filing a written statement stroke objection. Push up next para. Thus, comma, a strong prima facie case has been made out for hearing of the revisional application on the issues as to whether the learned trial judge was justified in permitting the written objection to the preemption case to be filed after a long lapse of 13 years, and as to whether, in view of the primary reliefs being sought against the opposite party numbers 11 and 12, comma, the opposite party number 1 ought to have been given the opportunity to file such written objection at the belated stage. First up, next para, the petitioner shall serve copies of the revisional application on the opposite party number 1, indicating that the matter shall be listed for hearing before the appropriate learned single judge having determination, subject to being mentioned for inclusion in the list before the said court by the parties. Push up an affidavit of service to that effect shall be filed by the petitioners at the on the returnable date. Push up service of notice on the other opposite parties is dispensed with.
One more thing, my lord, the opposite party number 11 and 12 already filed, my lord, an application under section 12, under order 12 and rule 6.
That will be good. What interim relief?
No, interim relief, my lord, stay of operation of the order by which, my lord, the defendant number 1 was directed to.
Then I have to stay the proceedings also.
Proceedings, my lord, this is my
that will be allowing the revisional application before hearing it. If they are restrained from relying on the written object, it's section 8, then it's written, not written statement, written objection.
No objection.
If they are stopped from relying on the written objection, then this you will get the preemption case disposed of without them. That will be allowing the revision before hearing.
That's right.
I'll stay both for a limited period so that you can extend. there shall be stay of operation of the impugned order as well as all further proceedings in why title suit?
It was mentioned in the, this should not be a title suit. But it was mentioned.
You're
in the-
sure it is under section 8?
Yes, 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 yes. Yes.
Not under the Mohammedan law?
No, no, no.
But the parties are Mohammedan. Just check
Yes,
up,
yes.
please. Check up. Where is your application? Main preemption application?
Yes, but I'm just. Let me go to it.
That has not been annexed.
No, that was not it.
Main preemption application is not annexed. দাঁড়া অর্ডারটা হোল্ড করো।
Yes, this is this.
No, Mohammedan law preemption. This is not section 8. This is a preemption under Mohammedan law. Section 8 যেখানে যেখানে মেনশন করেছে ওটা কেটে দিতে হবে, রিটেন অবজেকশনটা রিটেন স্টেটমেন্ট হয়ে যাবে।
Written statement. Then it should be.
Under section 8 একটা জায়গায় section 8 of the West Bengal Land Reforms Act বলেছি, ওটা কেটে দিন। Suit for preemption under the Mohammedan law. আর বাকি যা যেখানে যেখানে রিটেন অবজেকশন বলেছি রিটেন স্টেটমেন্ট, এক জায়গায় রিটেন স্টেটমেন্ট বলেছি বাকি জায়গায় অবজেকশন, স্ট্রোক হবে না, ওটা সব জায়গায় রিটেন স্টেটমেন্ট হয়ে যাবে। নেক্সট প্যারা, all further proceedings, the stay of operation of the impugned order as well as all further proceedings in title suit number 431 of 2010 pending before the learned civil judge junior division first court at Barasat district North 24 Parganas till March 31 2025 or until further order whichever is early.
I'm grateful to you.
Thank you.